parties are trying to dispossess the petitioner from his own land without following the due process of law, my lord.
Yes.
They are trying to dispossess, my lord, and if today, if this matter is not taken up, my lord, there is all chances that he will be dispossessed today itself, my
Today
lord.
it cannot be taken up, it will
Lordship.
appear on Thursday.
My lord,
What is the date mentioned in the presentation form
my lord,
for
Thursday,
listing?
my lord, Thursday.
Thursday,
My lord,
it will
kindly
appear
give
on
some
Thursday.
preference to this, my lord, because the
Lord,
petitioner shall
New
suffer.
motions will come at the top.
My lord, there is
I
another
think
matter.
I will be able to reach.
My lord, there is another
Always
matter,
I
my
have
lord.
reached all the new motions.
But there is another new motion, my lord. Herein, my lord, the petitioner is undergoing trial, which is a false case against him. Now, when he has gone to attend the dates of the court, my lord, the opposite parties have beaten up the petitioner in the court premises itself. The petitioner took steps by lodging complaints, my lord, but the police are idle spectators, my lord. Kindly take this up, madam.
Yes.
Lordship, may I be permitted to mention a tender matter? Lordship, it was supposed to appear on this date, but it didn't appear.
New
Lordship,
motion.
motion. Lordship, this is the order.
Motion. Hand over the slip.
My lord, may I allow to mention a matter, my lord? My lord, it's a new motion, my lord. My lord, I mentioned it yes. My lord, I mentioned it yesterday, but it's not
Under motion.
Yes, Lordship.
new motion.
Wait, let the new motions be exhausted, madam. Thereafter it will
May I
come.
permit to mention, my lord?
Unnecessary adding will not help. Please let me see. Let me touch the motions. It will appear. Please hand over the slip. You have mentioned yesterday.
Yes, Lord.
You need not hand over the slip again.
My lordship, may I permit
Additional plus, please hand over the slip.
My lord, may I permit to mention for correction?
Modification, application for modification. Hand over the slip.
My lord, may I
My
permit,
lordship-
I mentioned it yesterday, but it couldn't come in the list.
Under what heading?
My lord, new motion, my lord.
New motion.
New
It will appear. Yes.
Lordship, may I be
My
permitted to
lordship-
mention one motion application, my lord? It's in motion stage, my lord. For consecutive 2 days, I was trying to mention, my lord, but it has not. It is not in the list, my lord.
You have
So,
handed over the slip.
yesterday. I
Already,
handed
you
over.
need not hand over. Let me
My
see. Let
lordship-
me.
Lordship, may I be
see how far
permitted to
can
mention?
proceed.
Lordship.
Thereafter, motions will appear.
It's a ready matter for final hearing, your lordship.
Hearing, please don't mention now.
Milord, this is contempt matter, Milord. In today's list, Milord, it is 97, Milord. Kindly upgrade this, Milord. On
It's
6th,
first time.
first time, Milord. It is come. No, it is for the hearing matter. Contempt.
Contempt
Everything has
here,
been
is it for the
completed.
first time or the notice has been served?
It has already been solved.
Then it cannot be upgraded because let me see how far I can proceed.
My lordship, may I permit to mention
Correction,
my
please hand over the
lordship?
slip.
My lord,
My
for
lord-
correction, my lord. For correction.
Correction, please hand over the
My
slip.
lord,
43, what do you want?
just for upgradation.
Please wait. Let me see how far.
Correction.
My lordship-
Correction. For name.
Correction, please hand over the slip.
My lordship, may I permit to mention my lordship? I already mentioned a matter, my lordship, read matter
Hearing.
in this.
Final hearing, please wait.
Lordship, may I be
Why to
permitted to
mention?
mention the matter? Lordship, may I be permitted to mention the
Only then
matter?
it will be considered without their affidavits. Yes,
Lordship, may I be permitted to mention one matter?
Of today's list.
yes.
Your lordship, hear this matter today, my lord.
96.
96, motion, my lord. On the last occasion on 28th, this matter appeared in a lordship list. Due to non-availability of tickets, I failed to come to Jalpaiguri, my lord. I prayed for time. Your lordship directed the matter to appear on the next week, that is on the yesterday. Matter didn't appear. Today it is appearing as 96, my lord.
Yes, yes.
My lord, my dignity is for today, my lord, if your lordship kindly at any time, any time.
Consider the new motions are to be taken up first. Thereafter, I will consider.
My lord,
Let me see
at
how far
any
I
time, at any time.
Sir, you have got an opportunity. Your matter was moved once. There
My
are
lord,
some,
non-availability of tickets, my lord, I failed.
I appreciate that, but there are some who have not yet got an opportunity to move. New motions are to be taken up first, sir. Please let me see how far I can proceed.
Then, my lord, I'm waiting, my lord. Fine. I'm
Yes.
just
My
96.
lordship, may I
Yes.
permit to mention my lordship?
Lordship,
My lord-
Lordship, may I be permitted to mention?
Lordship, this is
Item number
for
one, yes.
item number 1. Lordship, this is for the rectification.
Yes.
This has been already.
Lordship, may I be permitted to mention one matter? Item number
Yes.
105 of your list for fixing it day after tomorrow, because the senior counsel will come from Supreme Court. It appearing under the thing application. This petitioner is written
105.
105.
It's under
Gyan
the
Vikas
heading
Bhandari.
application.
Yes, Lordship, it's an urgent matter, Lordship.
What is the
court-
application for?
Lordship, that is, I don't have the brief. I am not aware of the application. I just got instructed by the clerk.
Please take instructions. Please mention after knowing what is the application for. Yes,
My
call the
lordship,
next.
may I permit to mention, my lordship? My
Yes,
lordship, I mentioned a matter, read matter 195 of 2024 in the first date of this circuit, my lordship. The matter is not listed till date, my
under what
lordship.
heading?
My lordship, motion.
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 Please wait,
Yes.
it will appear. Yes,
Lordship, item number 1, this is for the rectification.
yes.
This writ petition has already been disposed of
No, maybe some mistake is
at page number 3, Lordship.
it's off. 2025. Oh. It has been pointed out that there is a typographical error in page 3 of the order dated October 29, 2025, wherein the number of the writ petition was wrongly recorded as WPA 1994 of 2025 instead of WPA 1996 of 2025. Let such error be rectified. This order shall form part of the order dated October 29, 2025.
Grateful,
Lordship, I am referring for the CGST, Lordship.
Yes, it's for correction only,
No,
Mr. Agarwal.
Lordship.
Yes. Mr. Agarwal, will it help that if I record your presence?
Lordship, because I am
all right.
acting.
At a record করে দিন. Mr. Agarwal, learned advocate, appears for the
CGST.
CGST authorities. ঠিক আছে? Yes.
Two million.
Yes.
Wife of the petitioner, here himself, herself petitioner, wife of the and next page, only pension and pension, not family pension. I corrected.
Oh,
First
oh,
bracket.
petitioner was the approved.
Yeah, petitioner is the assistant teacher, not wife of the petitioner.
No, assistant is this is the Gram Panchayat
Oh,
Kormi.
sorry, Gram Panchayat, Kurmi of the Gram. First paragraph, the wife of the petitioner, that is.
And it should not be the family pension, it should
Yes,
be the
only
pension.
pension and gratuity.
Pension. Gratuity has been mentioned.
Yes, yes.
It's only it has been pointed out that there are certain typographical errors in the order dated October 31, 2025. Full stop. In paragraph 2 of the said order, it was wrongly recorded that the wife of the petitioner was a Gram Panchayat Kormi, whereas the petitioner was herself a Gram Panchayat Kormi. Full stop. In the second page of the said order, a direction was passed upon the treasury officer to pay interest on gratuity and arrear family pension. Full stop. It is recorded that the interest shall be paid on gratuity and family pension and arrear pension and not on arrear family pension. Let such error be rectified. This order shall form part of the order.
Yes.
Call the next matter.
I am for the petition, my lord. Last occasion, your lordship was directed to report from the BLO.
Yes, my lord, as per your lordship order.
Yes, yes.
The illegal construction, my lord.
Yes, what is your instruction?
My lord. You have complied everything. After that, most cases.
Final reason order was passed.
Yes.
Oh, it was in 2024.
My lord, last occasion.
Panchayat Act, amendment. You can find that SU is the proper operative.
20?
Amendment of section 24.
Yes, 23-5.
Yes,
Amendment on 2017 with effect from 9th of November 2017.
That is the SU.
My lord, this is the second round of allegation, with petition, my lord. First round of litigation, my lord. The direction was given to.
No, but where is the order of the SDO?
There is no order. SU has not passed the order. We have not taken steps.
No, final result was accordingly forwarded to the O.
Forwarded.
And
the video.
the SDO has not,
And kindly.
so the SDO has to pass.
Kindly come to
Why the SDO is not taking steps?
kindly come to page number 52, my lord.
Video has complied.
Milords, I appear for the private respondent, Milords. As I'm paying for 1 day accommodation, Milords, I am yet to receive the brief, Milords. Yesterday night I was instructed, Milords.
I'm directing the SDO to take steps.
Milords, I
who
have
is
only
the-
one limited
Yes, Mr. Shah, you are representing the SDO also.
Yes.
Because I have limited instructions that after the inquiry that was held subsequent to the order passed by the previous writ court, Milords, my client has already demolished a part of the building
Lord, kindly see
which
the
is
pictures, my
adjacent
lord.
to the
All right,
Petitioner.
make those submissions before the SDO. The matter, SDO is not a party. You implead the SDO as a party. I give you liberty to make submissions before the
petitioner.
No, you are the private respondent.
Milords,
Allegation was against you.
Milords.
You have said that you have already complied with you have already
Yes.
demolished so you make submissions before the SDO. SDO will consider that and pass necessary orders.
Nothing, my lord. My lord,
All
kindly
right.
see this picture, my lord. My lord, kindly see this picture.
Milords, kindly allow me 1 day's accommodation. Milords, I'll come with all the documents and Milords, I'm yet to receive
I cannot decide anything here. I am
It's 1 day,
delegating to the SDO is produce all papers before the SDO. I am not going into that. Whether you have demolished, not demolished, I am not going into that. Ashun.
My lord, time limit may be given. Time limit may be given.
Yes. Pursuant to the order dated October 28, 2025, the concerned block development officer files the report dated November 3, 2025. The report of the concerned block development officer dated such and such has been filed in court today, which is taken on record. First of all, Mr. Shahal on an additional government leader submits that where is the order of the BDO?
52, my lord, kindly see.
52. Now, in this instruction you have annexed.
Yes, my lord.
Where is that?
Last part.
Look, copy may be given, my lord, to me.
Page 52.
46, my lord, the proper 40, come, my lord, kind of 46, my lord.
And Milords, one indulgence, Milords, as per my instructions, Milords, there are 2 adjacent buildings.
Yes.
The petitioner's building is on the right side of mine. Because my building was the first one that was erected. The petitioner's building was made subsequent, Milords. Milords, it's not that the petitioner's house was already existing, his boundary was existing, and after that I constructed my
Page number
building.
46,
Milords,
my lord.
the petitioner is the
number?
one who's
46, 46, my lord, 46.
49 is the reason for the.
49.
My lord, 46, my lord, the inquiry report, my lord.
Resident order of the executive officer, Panchayat Samiti.
It starts from 50 and the order portion, ordering portion is at page 52 much. Every 54, 52.
The 46, my lord, is the inquiry report, my lord. In pursuance of the order dated, in pursuance of the order of Calcutta High Court, WPA 1051, my lord. After consultation by second
Bola.
paragraph.
Additional government pleader submits that the concerned authority of the Panchayat after arriving at a conclusion that there is clear violation of section 23 within bracket 1 of the West Bengal Panchayat Act 1973 has forwarded the papers to the concerned subdivisional officer for taking necessary steps in terms of section 23 within bracket 5 of the Panchayat Act 1973 as amended by the Amendment Act of 2017. Full stop. The Mr. আচ্ছা, তারপরে দেখুন। The learned advocate appearing for the petitioner submits that no final decision has yet been taken by the concerned subdivisional officer. First of paragraph. The learned advocate appearing for the private respondent submits that the private respondents have already demolished the unauthorized construction alleged to have been made by the private respondents. Full stop. He therefore submits that as on date, there is no unauthorized construction on the property in question. Full stop. The learned advocate further submits that the construction of the private respondent was prior in time than the construction made by the petitioner,
And building plan obtained back in 2020.
and the construction made by the private respondent was in accordance with the sanctioned building plan dated in accordance with the building plan which was sanctioned sometimes in the year 2020. Full stop. Paragraph. However, since the permission granting authority, however, since the concerned authority of the Panchayat Samiti,
পঞ্চায়েত সমিতি পাস দেওয়ার
since the concerned authority of the Panchayat Samiti has forwarded has referred the matter to the concerned subdivisional officer, this court is of the considered view that the interest of justice would be subserved if the concerned subdivisional officer is directed to proceed in accordance with the provisions laid down under section 23 within bracket 5 23 within bracket 5 of the West Bengal Panchayat Act 1973 as amended by the Amendment Act of 2017. Full stop. The subdivisional officer shall afford an opportunity of hearing to the petitioner and the private respondent and pass an order in accordance with law as expeditiously as possible, but preferably within a period of, but positively within a period of, yes, Mr. Shah. Or any, after hearing the petitioner, private respondent, or any other party, who the STO considers a necessary party for deciding such issue. ঠিক আছে?
already inquiry have been done, my lord, and
The advocate of the party.
Within what time?
4 weeks, my lord.
Within a period of 4 weeks from the date of receipt of a server copy of this order.
my lord, I am directed to serve the copy to the, my lord, SDO, my lord.
Please implement the SDO. I am
Yes,
giving you
my lord.
liberty.
Yes, my lord.
Uh,
And keep the matter pending, my lord.
আচ্ছা, ওই যেখানে বললাম না মিস্টার শাহ সাবমিশন, যেখানে বললাম যে ওখানটা কি লিখেছেন একটু বলো। petitioner, যেখানে ওই ঠিক তার আগেই লিখুন, faced with such situation, the learned advocate appearing for the petitioner prays for leave to implead the subdivisional officer Shodor Jalpaiguri as a party respondent in this writ petition. First up, as prayed for by the learned advocate for the petitioner, leave is granted to the learned advocate on record of the petitioner to add the subdivisional officer Shodor Jalpaiguri as a party respondent in this writ petition. First up, since the state is represented, there is no necessity to serve a copy of the writ petition upon the concerned subdivisional officer. First up, the learned advocate on record of the petitioner shall be obliged to serve a copy of the amended cost title of the writ petition upon the learned advocate appearing for the state and the private respondent in course of this week. ঠিক আছে?
The matter is pending, Milord. Milord, kindly, Milord.
With the above observations and
Milord, kindly, Milord, this is the second round of litigation, Milord.
you have
Thereafter-
remedies,
Milord, kindly,
no
Milord.
steps is taken, you have
After 8 weeks, matter maybe list, Milord. Kindly, Milord.
yes.
Milord,
Milord, at the time of hearing, kindly the advocates.
আচ্ছা, কি হলো? Who, according to the subdivisional officer, may be a necessary party for deciding the issue referred to it. ঠিক আছে? এইবারে লিখে দেবেন ওই লাস্টে it will be open to the respective parties to raise all points before the subdivisional officer and place materials in support of their respective contentions.
Yes, Milord, at the time of hearing,
Milord, kindly
the
take it,
advocate of the party.
With the above observations and directions, WP.
Milord, kindly pick it
Stands
for
postponed.
8 weeks, Milord. Milord, kindly let the matter list under after
No.
8 weeks, Milord.
Let's call the next
Milord, this is
matter.
the second round of litigation, Milord. Another have to file, Milord.
Yes,
Their
yes.
intention, they are not complying the order, Milord.
Yes.
Milord, kindly, Milord.
Call the
Let the
next
matter
matter.
be pending.
4, 5, I'm for the respondent number 5 and 4 and 5. Panchayat.
My lord, I appear for the petitioner in item number 4 and one of the private respondent in item number 5, my lord. So this has been
Yes.
fixed for order.
Yes.
But my lord, if your lordship kindly, I have been engaged yesterday only. If your lordship grants me 1 day accommodation, I can come back with better.
Who are you? Who are you?
He is a newly
I
engaged
am
counsel,
appearing.
I
I
am
am
the
appearing
erstwhile counsel,
for
I have given the NOC, He is a newly
So it
engaged
has
counsel.
been, hearing has been concluded, no further hearing. Assun,
my lord. One thing
for
I
all
have
the
noticed-
reasons as aforesaid,
I am the
WPA
petitioner appearing
2138 of 2025 stands. না, লেখার দরকার নেই। For all the reasons as aforesaid, WPA 2138 of 2025 stands dismissed. WPA 2140 of 2025 stands allowed by directing the subdivisional officer, Alipurduar, being the third respondent to effect demolition of the unauthorized construction of the building in question as expeditiously as possible, but positively within a period of 8 weeks from the date of receipt of a server copy of this order and impose a fine as may be specified by the state government and recover the cost thereof from the owner as a public demand. The order dated June 14, 2025, passed by the subdivision officer is modified only to the extent as indicated herein before. No order as to cost. Yes.
Abhilash Bose.
Yes, call the next matter.
My lord, item number 6, I am for the petitioner, my lord.
Yes.
I am appearing virtually, my lord. My lord, one of the unfortunate incident takes place, my lord. My lord, petitioner, as the age about petitioner number age about 76 years, and petitioner number 2 as the age about 70 years, my lord. They are the recorded owner of the land situated at Mouja Bhimram, block Naxalbari, district Darjeeling, being LR number 2558, LR Khotiar number 200 and 500, and which I have annexed, my lord, all the my records of right in page 13, my lord.
Page
13.
1-3.
1-3.
Yes, what do you want?
My lord, private respondent number 5 and 6, my lord.
Yes.
In recent time, my lord, illegally encroach my property, my lord.
Lordship, this
And-
is totally a civil dispute, Lordship.
My lord,
Where is your representation?
my representation start from, my lord, 39, my lord. I representation to the local Naxalbari Gram Panchayat. Thereafter, my lord, Naxalbari BLL, LRO, my lord. And one of the unfortunate incident, my lord, on 16 of August 2025, when my wife entered into my property, my private respondent threatening him to killing himself, my lord. And on the day, my lord, representation before the local police station of Naxalbari police station, which I have annexed, my lord, page 41. My lord, they are threatening him to killing themselves, my lord. Thereafter, I made representation before the Commissioner of Police, Siliguri Police Commissioner, my lord. We have annexed page 47. And thereafter, my lord, I representation before the earlier on occasion on 8th of August 2025, I representation before Naxalbari Gram Panchayat. But no single step was taken, my lord. I am the oldest person, age about 76 years, and my wife 70 years, my lord. I am recorded owner of the land, my lord.
So you have been dispossessed from your property.
Let them approach the
Yes, my
civil
lord,
court,
yes.
Lordship, for
My lord.
recovery.
My lord, they do not enter into my property, my lord. They threatening him to continue, threatening him to killing themselves, my lord. My lord. My lord, kindly consider my representation, my lord.
Which representation you want me to consider? You have filed several representations. Show me the representation we want the court to consider.
My lord, I am representative of the police, my lord. Local police station, Gram Panchayat to take back my property, my lord.
Not the Gram Panchayat. Please restrict your
No,
submission
my
for
lord,
one
I also
authority.
representation before Gram Panchayat, my lord.
Gram Panchayat. What
Yes,
the
my
Gram
lord,
Panchayat will do? Sir, what the Gram Panchayat will do?
My lord, Gram Panchayat is the local administration, my lord.
Oh,
My lord,
can pass an order of eviction? Show me under the provisions of the Panchayat Act.
my lord, I also represented your police, my lord.
That is
My
why I'm
police have
asking
the
you.
power.
You want which authority to consider your representation and which representation to be considered? Please show me that.
My lord, kindly say page 41, my lord. Kindly. My lord,
Yes.
threatening himself, my lord. Kindly. No, I have recorded owner of the land, my lord. I have annexed all the documents. All
Sir,
the
when have you been dispossessed?
my lord disposes from 8/2024, my lord.
2024. What is the date?
Date, my lord. 12th of July, my lord, 2024.
7th of July.
12th of July, page 39, my lord.
39.
Please come to your paragraph 4. You have stated 7th of July 2024.
On 2024 from my disposes my property, my lord.
Yes.
From 2024, my lord.
What is the date?
12th of July, my lord. Annex we have page 42, my lord.
Page
42. We have stated in representation, my lord.
42.
Yes. Who is for the private respondent? Have you served upon the private respondent?
Yes, my lord. Yes. This is successfully, my lord, served on affidavit service. This is affidavit of service, my lord.
Yes.
It is successfully delivered to the addressee, my lord.
It has been delivered.
Private respondent are.
Yes, madam. What is your instruction?
Lordship, first of all, the matter is totally civil in nature and civil dispute. Lordship, they let them approach before the civil court to recover your possession, Lordship, because they already dispossessed. And besides this, Lordship, we have initiated under section 126 of BNSS, Lordship.
For what?
For maintaining peace and tranquility in the against the private respondent lordship.
Prosecution under section 126.
BNSS lordship, that is
Yes,
the
Paliyot.
107 CRPC in the earlier.
Earlier provision.
Yes, lordship. And this is after the representation lordship. Against the private respondent, we have initiated the prosecution case. And lordship, in his each and every complaint, it is clearly mentioned that this matter is totally civil in nature, lordship.
The petitioner, Asun, affidavit of service filed in court today is taken on record. First of the learned advocate appearing for the petitioner submits that the private respondents have been duly served. Full stop. None appears for the private respondents. Full stop. The petitioner claims to be the recorded owner of land situated at so is the recorded owner of land being LR Dag number 2558, LR Khotian number 200 and 500 under police station Naxalbari in the district of under police station Naxalbari within Mouja, Bhimram in the district of Darjeeling. First, the petitioner alleges that all on a sudden on July 7, 2024, the respondent numbers 8 and 9 came to the plot of the petitioner and started to grab the possession of the said land for the purpose of setting up illegal possession of the property. First up, the petitioner further alleges that when the petitioners resisted the private respondents, they threatened him of dire consequences. First up, the petitioner claims to have lodged several representations before various authorities, including the officer in charge, Naxalbari police station. First up, paragraph. The learned advocate appearing for the petitioner submits that in spite of the fact that the complaint has been lodged before the concerned police station, no steps have been taken pursuant to such complaints by the police authorities. Full stop. Paragraph. The learned advocate representing the state files a report of the Sub-Inspector of Police in charge of Naxalbari Police Station dated November 3, 2025. Full stop. Now, full stop. Now, which is taken on record. Paragraph. After going through the nature of the allegations made in the complaint lodged before the officer lodged with the officer in charge of the local police station and the averments made in the writ petition, this court is of the it appears to this court that the dispute between the petitioner and the private respondents is purely civil in nature. Full stop. The petitioner alleges dispossession from an immovable property without due process of law. Full stop. It will be open to the petitioner to approach the competent court for redressal of approach the competent civil court praying for reliefs in respect of alleged forceful dispossession from an immovable property. Full stop. Neither the police authorities nor the panchayat authorities have been vested with the power to decide an issue regarding wrongful disposition of a person from an immovable property. Full stop. The it appears from the report filed by the police officer in charge, a report filed by the sub-inspector of police in charge of Naxalbari police station, that pursuant to the complaint lodged by the petitioner, a prosecution under section 126 BNSS has already been initiated. First of the learned advocate appearing for the state further submits that the police authorities are keeping a strict vigil at the locale. Full stop. In view thereof, WPA number such and such stands disposed of by directing the officer in charge, Naxalbari police station, to maintain peace and tranquility at the locale and to keep a strict vigil so as to prevent any untoward incidents.
Grateful, man.
Yes. Call the next matter.
7, my lord, I approve the petitioner.
Lordship, kindly fix the matter into Friday, Lordship, because we need the instruction.
Yes,
Because-
what is this?
But
what
may
is the issue?
I pay for a leave to file the affidavit on service in course of the day, my lord?
It has been served.
Yes, yes.
Yes, what do you want?
My lord, the petitioner is a citizen of Nigeria. My lord, he is facing a criminal case in Kashiong. That case was initiated in 2014. At that point of time, my lord, he was convicted for another offense in the state of Meghalaya, and he was suffering imprisonment. After that was done, my lord, he was produced before the learned court at Kashiong. He was remanded to custody for some time. Then, my lord, he obtained bail. Now he went to, in search of some employment, my lord, he went to Tripura, where he was again arrested because he was not traveling with proper documents. Convicted under the Passport Act, he completed his conviction, my lord, and now he's in a detention camp. The difficulty is, my lord, that the investigating officer here, my lord, though the charge sheet has been filed, has not taken much steps to bring him from Agartala to Kashiong, my lord. And as a result, my lord, he's not been able to face trial here. And he is, my lord, now in detention camp because of the pendency of this case. He is not able to go
They have
there,
to
my lord.
file a report. I have to
Yes,
follow
my
up
lord, he has to
from
file a
them.
report.
Yes, how soon can you file the report?
Lordship, it will be better to fix the matter next circuit or either.
Yes.
Yes, Lordship.
File the reports in the meantime.
Yes, Lordship.
How much time you want?
1 week, Lordship, because,
1 week.
yes.
Considering the nature of the allegations made in this writ petition, this court feels that this court feels that this court directs the who shall file?
Who will file? Ye file.
Inspector in charge, Darjeeling.
Detective Department, Siliguri, CID. Yes, CID is now in charge.
CID, Lordship.
This court directs the Inspector of Police, Darjeeling, DD, that is Detective Department.
Yes, Lordship.
Detective Department, Siliguri, CID/West Bengal, being the 7th respondent, to file a report in the form of an affidavit within a period of within a period of 2 weeks from date. Full stop. list this matter
ঠিক আছে, 2 weeks ঠিক আছে।
before the next available circuit bench, subject to the convenience of the bench.
Grateful.
Grateful.
My lord, may I file the affidavit of service in course of the day, my lord?
Leave is granted to the learned advocate on record of the petitioner to file the affidavit of service in course of this. এটা একদম উপরে করে দেবে না?
Great.
আর ওখানে লিখে দেবেন the learned advocate appealing for the there is no
No,
private
no, no, no.
respondent.
The state respondents.
State respondents have been served.
Yes, yes.
ঠিক আছে।
Great.
Yes, next. Yes.
Lordship, am I audible?
Yes, yes, very much audible, visible, everything. Yes.
Yes, Lordship, item number 10, item number 8, 9, 10, 11, and 13, Lordship. I'm only praying for Lordship for next circuit. This
Why?
is
Why, Mr.
only,
Banerjee?
yes, only Lordship, because this Lord. Yes, but the matter has not yet been served also, Lordship. This is a NREGS payment. One matter, Lordship, has already been transferred to the principal bench. The matter will be heard on 7th. I have mentioned it yesterday before the Chief Justice bench. Only I'm accommodation prayed for. Lordship may kindly take up the matter direct for the next circuit under the same heading.
Since the service has not been effected, list this matter before the next available circuit bench. First, a petition is directed to serve a copy of this writ petition upon the respondents and file an affidavit of service on the next date. First up, the learned advocate appealing for the petitioner further submits that that an identical issue is pending in a public interest litigation before the principal bench.
WPAP 237 of 2023.
WPA within
P.
bracket P
237 of 2023.
237 of 2023. Full stop. He submits that the said public interest litigation is expected to be taken up very soon. Is expected to be taken up very soon. ঠিক আছে?
Lordship, 8, 9, 10, and 11 both are same, can be passed. 8, 9, 10, 11. Lordship, just a second. Lordship, just a second. And 13.
13.
13.
8, 9, 10, 11, and 13, same order.
Yes, Lordship. Grateful. I'm grateful.
Yes. Yes, call the next matter.
Well,
Yes,
well, my lord, I am
yes,
led
Mr.
by-
Das.
led by Mr. Prosenjit Das.
Where is he?
Your Lordship, this is a matter due to non-constitution of tribunal. I came before your Lordship, it's GST matter. So I pray for staying of this matter. I want to rely on judgment passed by your Lordship.
Who is appearing for the CGST or WBGST?
The affidavit has been served.
No, it is it CGST or WBGST?
West Bengal, West Bengal.
Yes, who is appearing?
My lord,
Who is appearing for the state?
this item number.
Yes, Mr. Rahman, where is Ms. Sarkar? Who is appearing in revenue matters apart from Ms. Sarkar? Yes, what is this matter?
Your
What is the
Lordship,
issue?
before going to the issue, I just want to rely on judgment passed by issue because tribunal is very soon will be constituted. I just praying for a stay during the pendency, and there is a factual aspects regarding ITC also, which has been not availed. So that's why I request your Lordship to place the matter before the available tribunal and stay this matter till disposal of still constitution of tribunal. I placed one judgment passed by your Lordship.
What is the order impugned which you are challenging?
Your Lordship, order impugned is in page is in page 25. Your Lordship, starting from
page 25.
Yeah, starting from page 25. This is the appellate order. by the State Appellate Authority.
Where is the order passed by the adjudicating authority?
Your Lordship, adjudication order is on page 47 starting from.
Detailed order, page 51. Yes. Yes. Tribunal has been constituted.
No, your Lordship, State Tribunal is not yet constitution, no option of filing of any appeal. I
Yes.
think my learned government pleader will also agree with me. I can't hear him, your Lordship can. I can't.
Not constituted as of yet.
Yes.
Your Lordship.
Yes, so the GST Act in
Section 112.
I have referred one circular, your Lordship, in this regard. If my friend, learned friend can give 2019.
EBC 2016.
2019. And a division bench judgment on this matter. Circular number 132 by 2 of 2020. Central Board of Indirect Taxes and Custom, GST Policy Wings. Dated 18th March 2020. If your Lordship allow, I want to place the circular, department own circular before your Lordship. My friend will hand over.
Yes, Mr. Das, please take it. You have given 2 copies. Yeah. Yes. Where is the order of the division bench which you wanted to rely upon?
It is Jai Venkatesh, your Lordship. Jai Venkatesh. I want to rely Jai Venkatesh of Division Bench Calcutta High Court and Rocham India Division Bench of Bombay High Court. Both the order has been, along with this notification, has been already considered by your
Mr.
lordship
Das, where are those judgments? Give me.
by an order. Your lordship has already been considered both the judgment in a consolidated manner. That is Jaskan Lunavat, your consolidated judgment, your lordship.
Jaskan Lunavat has been carried on in appeal. It has been clarified.
Not stayed. Not
Yes,
stayed. Department challenge, not stayed.
Yeah, it's the department. Yes, the state has challenged him.
State has challenge, not yet stayed.
No, it is not stayed. It has been modified. Order has been passed.
Yes, where is the order of the Division Bench of the Calcutta High Court?
That is the name of is Jai Venkatesh. Jai Venkatesh.
Concast Limited.
Yes.
Jai Venkatesh Concast.
Jai Venkatesh. MAT 720 of 2023.
Yes. Jai Venkatesh. My lord had relied on this judgment, which my lord had passed in single bench. My lord subsequently, that judgment was carried doing appeal, and division bench of Honorable Justice Kaushik Chandra was pleased to direct that the statutory deposit as stipulated in under section 112 is to be deposited.
But this division bench order has not yet been challenged, your lordship. Neither the Bombay High Court nor the Calcutta High Court division bench.
Yes, this is challenging this the earlier matter, the Jaskaran Lunavat. This has been modified to that extent, this order of your lordship.
Yes. Give me, where is that?
Not, I have to take it. I don't right now have the copy of that. That's Justice Kaushik Chandra's order. It's sitting in the division bench.
Yes.
I'll take it out.
But Calcutta High Court division bench order and the Bombay High Court division bench order has not yet been challenged by any of the higher forum.
Yes, but it's the discretion of the court. Court can direct you to deposit the pre-deposit also.
Lordship.
It's the court's discretion.
Your lordship.
Further, my lord. Previously it was 20%. Now it is made 10% by virtue of
Your lordship your lordship the section. Your lordship the section. What the section says, your lordship, can you your lordship, I request just come to the circular where the pre-deposit I will pay, but the time of paying pre-deposit at the time of filing of the appeal. At the time of filing of the appeal. And for non-constitution of the tribunal, it is not a fault of the SSC, your lordship. I am ready to go before the tribunal with all the formalities and the provision laid down in section 112. And the circular I have referred, it is already incorporated in the act, section 112. In the footnote, it has been clarified.
There are two ways of looking at it.
Your lordship.
One is there is no effective appellate remedy at present. So a writ petition is maintainable at the present point of time. You have invoked the jurisdiction under Article 226 and you are praying for an interim order. So if you are praying for an interim order, you may be directed to deposit to comply with the pre-deposit. If that is deposit, you need not further deposit when you prefer an appeal. That may be made clear. So you will not be required to deposit over and again. But since you are praying for stay now, please deposit that amount. I will make it clear that when you prefer an appeal before the tribunal, you need not make a further deposit of the amount as indicated under section 112. 8.
In MAT 35, that appeal I was referring to.
Yes, you have got the order.
Yes.
Yes, give me that.
MAT 35, 36, and 37. There were 3 separate cases of 2025. Yes. It was carried out in appeal, carried on to appeal by the state regarding the statutory deposit, payment of statutory.
But one thing, this is contrary to the earlier division bench judgment that was not taken into consideration. Wherein this Joy Venkatesh, it was the judgment of 12th of May 2023. Was not placed. And this is an order of 2025.
Yes.
2023 judgment was not placed.
But this is only with respect to recovery proceedings. Now it takes up paragraph number 6 of
Yes, yes. And here is also
proceedings are
recovery proceedings.
Automatically stayed. We don't, recovery proceedings are automatically stayed upon.
No.
Preferring
With regard to this writ petition,
yes, madam.
please kindly come to this Joy Venkatesh.
Yes, madam.
Recovery proceedings shall remain stayed
Yes.
without imposing any precondition. And here it has been said, no, that is to be paid. So this is contrary to this.
No. Recovery proceedings is already stayed once the appeal is preferred, madam. That is.
Appeal is yet to be preferred.
They are preferring the appeal, madam, before the appellate authority.
There is no appellate authority now.
No, but
After that.
After that.
Now, please see this order.
Yes,
This order, there are two things. Now, they have paid for stay. If you say there is no recovery proceedings, I will record your submission. There is no recovery proceedings.
As of
There
yet,
is-
not. As of yet, not.
You will not initiate also recovery
Well,
proceedings.
it is already stayed as per the statutory provision.
How? No appeal has been preferred, sir.
Once it is preferred under 112, it is automatic.
If it is preferred,
Yes.
so unless and until a tribunal is constituted, you will not initiate any recovery proceedings. I will recover that.
My lord may stay the recovery proceedings.
Yes. Now, the question is, if it is to be stayed, now whether, please open this. Whether this pre-deposit is to be directed to be paid, because this Joy Venkatesh says there is no necessity to deposit further 20%, and that division bench, without considering the earlier division bench, has said no, it is to be deposited.
There are also other judgments of the other high courts also wherein this deposit has been directed to be paid.
So there are not the other. It was a binding precedent. It was an earlier judgment. So what do you say? What is the effect of the subsequent division bench judgment? We did not take into consideration the earlier division bench judgment.
Recovery proceedings can remain stayed without imposing any precondition. That might not can pass an ordinance. So once they
And state the operation of the order passed in appeal.
Yes, my lord, that has to.
Yes, such right. So
once they file the appeal in under 112, only then they are required to make the deposit. As and when they file the appeal.
But here in this judgment which you are referring to, it says no, cannot be stayed without that precondition. How do you reconcile this?
That is basically as and when the appeal is filed under section.
Cannot be
112.
Cannot be 112 as and when it is filed. Yes, okay. But here that was modified by saying No, it has to be stayed subject to the pre-deposit.
No, my lord's order, my lord takes up my lord's order. My lord's order is not on that aspect, my lord.
Yes,
my lord
please.
takes up my lord's order here.
Where is that? Please give
That
me.
is WPA 1881 of 2020.
Which was taken
Rule
in
of-
appeal.
Yes,
Yes, please give me that.
My lord, it is before your lordship. It is before your lordship, Lunawat's order.
Jaskaran Lunawat.
Yes.
That goes through my lord's order.
Right.
Yes, for being favored with an interim order.
Yes, that is.
So interim order
my lord's,
in the writ court.
Yes.
So interim order, they have also paid for this.
Yes.
So this was the issue.
Yes.
And so two conflicting views of two division bench. What to be done?
My lord's order was perfectly okay. My lord's perfectly right in context of section 112. The only aspect that my lord might have omitted to mention was that regarding this pre-deposit. That is why it was carried out.
No. I'm not on that. So now the interim order, this was also on interim order without imposing any condition
Without imposing anything.
in a writ petition.
The recovery is already stayed, my lord.
In a writ petition.
Yes.
So interim order not to give any effect. That
Yes.
means you cannot initiate a recovery process.
Yes, we are not initiating.
Not to.
Yes.
So Joy Venkatesh says no. There is no necessity for depositing the further amount in a writ petition. And this order says yes, there is necessity. Two division bench judgment. Let me please tell me what should I now
Let
do?
me refer the matter for the lottery. My lord is there, so because this is something that needs to be decided.
Why? What is the law of precedent?
That, my lord,
Please tell me.
that, my lord, is
What is the law of precedent?
the earlier order if not appealed against quickly.
And what is the effect of the subsequent decision not taking into consideration the earlier division bench?
Very
Then
this issue is a burning issue in many of the high courts. So,
maybe, but after considering
Yes.
that, the division bench decision ought to have been
that ought to have
considered.
been taken out in appeal before the Honorable Supreme Court because that was a division bench. Appeal. So,
What is to be done now?
well, if I may suggest something, my lord stays the recovery process. Anyway, the recovery proceedings is going to remain stayed once the petitioner approaches under section 112. My lord may stay the recovery proceedings and.
So I will record your submission that he will not initiate any recovery proceedings in the.
My lord, directly stay the recovery.
No. Staying will be which course to be followed.
My lord,
Please take it on your own shoulders. I will record that. Don't put it on the shoulders of the court. There are two conflicting.
Well, I would have taken the responsibility. The only difficulty is that I am not the counsel engaged in this matter directly.
Ask Ms. Sarkar to come.
Lordship. I would have otherwise.
Ask Ms. Sarkar to come.
Lordship.
Because that is the difficulty. Because look, there has to be a consistency.
Well,
so now, in order to take that consistent view, there has to be one line of decision. If there are two conflicting views of co-equal benches, what will happen? What will happen? That is the. Yes, Mr. Das, what is the law? If there are two division bench judgments on the same field, which is to be followed? Because your learned friend is referring to another division bench judgment. If you want to consider that and come back, you are free.
Your Lordship, this matter is definitely a matter. Apart from that, I want to submit one thing, that in this case, this point, section 112 is troubling the other side, but there is a violation of natural justice. Single bench order is there, show cause notice and order is unsigned, DRC 01, and no opportunity of hearing has been granted. And it is mentioned in the order, no opportunity.
No, if
was
you are on
mentioned in the
merits,
order.
I will take it up, sir. If you are on merits.
No, I am not going to merits.
Yes.
I want to stay. I want to stay. Simple
If you are on merits, I will decide it on merits.
No,
Then I will
simple
not
stay.
allow you
Simple
to
No, no.
move before the tribunal.
Simple stay.
Please
Then
take a
I would
conscious decision whether
conscious
to move it
decision
on
section
merits or to
112.
go before the tribunal.
112.
If
Section
you want,
112.
please, Mr. Raman, please give him a copy of the reference. So that,
But your lordship, I just got the copy of the division bench, your lordship, by the authority. In that order, I think the second order, it is a kind of other side, appellate side may not have appeared, I think. This is a,
maybe
whether
appeared or not appeared, an order
considered.
passed, it's binding.
It's
An
binding.
order. Do you mean to say that the ex parte order do not have any force?
No, it have, but all things has not been
It was the
considered.
choice of the party whether to appear or not.
Your lordship, grateful.
That
I
does
bow
not,
down before your lordship.
Yes.
I bow down. I bow down. I bow down. my lordship.
Ashwin.
But the division bench order has not been challenged by the department. The Jaskan Rulawat has not. The Jai Venkatesh has not been challenged by the state of West Bengal, and Rocham India has not been challenged by the state of Bombay.
No. That is a different thing altogether.
Your
But
lordship.
here I am faced with two division bench judgments.
Grateful. I
That's the
understand.
difficulty. And
I
both
understand.
are binding on me. And tell me what recourses are to be followed here. There are judgments in identical cases. What is the recourse to be followed? I'm aware of those, but I want you to also to do some research work. The learned advocate appearing for the petitioner submits that though the order impugned in the writ petition is an appellable one, but the tribunal or the appellate tribunal.
Tribunal.
It's the appellate tribunal.
Appellate tribunal. Appellate tribunal. Appellate tribunal. Section 112.
But
Appellate
the
tribunal.
appellate tribunal is yet to be constituted. Full stop. The learned advocate appearing for the petitioner prays for an interim order restraining the respondents from giving any effect to and or taking any steps pursuant to the appellate order dated September 11, 2025. First of the learned advocate appearing for the petitioner places reliance upon an order passed by the Honorable Division Bench on May 12, 2023 in MAT 720 of 2023 in support of his contention that in support of his contention that the petitioner could not have been directed to deposit 20% of the disputed tax.
10%, your lordship.
Or paying
10%, additional 10%. 10%, your lordship.
No,
10%.
the statute says 20%.
10%. Now it is modified to 10%, your lordship. I think my other side will agree to it.
All right,
it has been amended to 10%.
Could not have been directed to deposit 10% of the amount in addition to the amount paid under subsection 6 of 107 as a condition for passing an interim order.
If I may, regard stop.
Regarding this Jai Venkatesh, my lord, if my lord notes that the content, the facts of the said case, it was a case wherein both the CGST as well as the HGST authorities had parallelly initiated proceedings.
That was on merit.
Clear. On the peculiar circumstances. of
That
the
was
case,
on merit.
Yes.
But here it was on whether that could have been directed. Full stop.
That was that matter has already been referred to in your lordship's order.
Yes.
That was part of the single bench.
The learned advocate appearing for the petitioner further refers to a decision passed by in Lunawat, the division bench judgment was referred to.
Yes, my lord, takes up the WPA, my lord, the fourth para in the first page.
Oh.
Your lordship has considered both the judgment,
Both the judgments
division
are,
bench and Rocham
this
India.
was distinguished. This particular judgment was distinguished, but your lordship was pleased to disallow the said contention raised by the state. This was distinguished. This particular Jai Venkatesh concurrence was distinguished.
Yes, I relied on that Jai Venkatesh.
Yes, my lord, this was distinguished by the state advocate. My lord, takes
No,
up-
no.
No,
Yes, but it, this was relied upon.
Yes. This was
Now,
relied upon by the
the
petitioner.
division bench, so the division bench was aware of the earlier division bench judgment.
Yes, but this was it was.
How
treated
could it
because-
be done?
Well, this was with regard to the peculiar facts and circumstances of that particular.
That was not mentioned here.
That
Show
is-
me.
That is not mentioned, but
Then-
my submission was that before the division bench.
Maybe, but that was not mentioned.
That is something.
So
that
the
like-
courts open to the subsequent division bench was only to refer.
Well, it takes up page number 2, third paragraph.
Raja,
Well,
ki bola?
let's repeat that.
The learned advocate appearing for the petitioner further refers to a decision passed by this court in WPA 1881 of 2020. Ki bolo? Passed by this court on order decision order passed by this court on January 8, 2024 in WPA 1881 of 2023 in the case of Jaskaran Lunawat versus State of West Bengal and others. Wherein this court, after taking note of the decision of the Honorable Division Bench in the case of Joy Venkatesh Contas Private Limited Supra, passed an interim order without requiring the petitioner therein to make any deposit as specified under, as stipulated under section 112(8) of the WBGST Act. Full stop. Mr. Rahman, learned advocate appearing for the state, submits that the order dated January 8, 2024, passed in the case of Jaskaran Lunawat Supra in WPA 1881 of 2023 was modified by the Honorable Division Bench in.
That is MAT 30. There are 3 cases, my lord. This is the third case, Jaskaran Lunawat. So the this appeal connected.
As against this, what is the appeal number?
MAT 37.
MAT 37 of
2024.
Of 2024, wherein the Honorable Division Bench was of the view, wherein the Honorable Division Bench expressed the view that for passing an interim order, an amount as stipulated under section 112(8) is to be made. It prima facie appears to this court that there are 2 conflicting decisions of the Honorable Division Bench on the self-same issue. Full stop. The learned advocate appearing for the petitioner prays for an accommodation to consider the decision passed by the Honorable Division Bench in MAT 37 of 2025 and to revert back on the revert back to the court on the next occasion. This first up, list this matter before the next available circuit bench under the same heading. Grateful.
Grateful.
Every service filed in court today is taken on record. কি বললাম? It appears to this court that there are the question therefore arises is which of the aforesaid two decisions shall be the question that arises for consideration is which of the aforesaid two decisions shall be applied to the case on hand. তারপরে লিখুন ফেস্টন। Grateful. Yes, next.
49 for this page. Well, this matter was returnable on 6th month.
6th of
November.
Lordship, in item number 14, Learned Senior Mr. Bodhan Bhattacharya is appearing, Your Lordship. He is having his like before the division bench, Your Lordship. I am praying for a short person.
Well, it is returnable on 6th of November.
In the notice?
Yes, right.
The learned advocate appearing for the petitioner prays for an accommodation on the ground of his learned senior. First of the learned advocate appearing for the state submits that in the notice issued to the state, it has been indicated that this matter shall appear on November 6, 2025. First up, in view thereof, list this matter on November 6, 2025. Under the same heading. Yes, next.
Lordship, I am praying for a parcel. I am praying for a parcel.
What parcel? 6th it will appear. You have in the notice you have said
Right.
it is on 6th.
15, Your Lordship.
15, let me see. Let that be called on.
Oh.
15. Yes, 15. Who is appearing?
Yes, my lord. It given on 6th.
Same order. Next.
My lord, my senior Mr. Bodhan Bhattacharya is appearing before division.
Madam, what can be done? In the notice you have said that it will appear on 6th. What are you doing? In the presentation form you have mentioned the date as 4th and in the service copy you have mentioned as 6th. Yes. Who is appearing?
But in this with me, Rima is assisting me. It's Sarkar.
Yes, who is for the petitioner?
My lord, Mr. Bodhan Bhattacharya is appearing for the petition.
Yes.
My lord, he's on his legs before the portal number
Yes,
1.
what is the returnable date in your notice?
No, my lord, it is fine. It is
You are ready, yes.
instructions when received.
Yes, what do you want? You want Passover?
No, returnable is on 6th, it is written.
All right. Return date is 6.
6th written, but we are ready, my lord, with the
All right,
instructions.
Passover next. Yes.
My lord, I'd like to appear online, my lord.
Yes, yes.
My lord,
Lordship, I am appearing for the respondent, Lordship.
my lord, this is a challenge to the first appellant authority's order under section 107. This was passed in limine, my lords. No adjudication on merits was happened, my lords. Only no opportunity of personal hearing was granted to rectify any deficiency which they have cited in the order. The order is at, my lord, page 175, the 11th portion. My lord, what happened was when the appeal was filed, the pre-deposit, the provision was already introduced by way of Finance Act 2025, wherein the pre-deposit was made at 10% of the disputed demand. I deposited under an impression that it has been notified, although it was not being notified. It was notified subsequently on 1st of October 2025, my lords. My appeal was filed on 19/9/2025. Subsequently, they offered me a personal hearing. They did not give me any opportunity to rectify that defect. They did not even pointed out that defect. Law mandates them to point out this defect in APL 02 if there is any deficiency in the appeal memo. Stating it has been
Lordship, may I have the one suggestion, Lordship?
Yes.
Lordship, have the liberty to relegate the matter to the appellate authority to giving the direction to petitioner to deposit the additional 15%. Because this is only the short issue.
My lords, now the question, the dispute is now being settled. They themselves have recorded in the order that the disputed amount of 10, the pre-deposit of 10% has now been notified with effect from 1st October. So let them
Sir, appeal is before that notification, learned council. So you are liable to pay the 25%.
My lords, my lords
25 or 20?
My lord, 10%, 10%. My lords may have section 107, subsection 6. Proviso.
Yes, 107,
subsection 6. Latest.
Lordship, this appeal is filed on
this is an
August
appeal
and the
under section
subsequent
107.
reduction is in September, Lordship.
Subsection 6, proviso, my lords. It's as amended by Finance Act 2025, the latest, my lords. My lords have it?
No, it was 10%.
Yes, my lords. It's 10%. I deposited 10%. It was being reduced, my lords. I accepted that this was reduced on 1st October 2025. Earlier it was 25, but from 1st October 2025, the provision was notified and the pre-deposit amount was reduced to 10%.
No. What was the earlier provision?
Earlier provision was 25%, my lords.
So this is the amendment?
Yes, this is the amendment, my lords.
No.
It's as amended by Finance Act 2025, my lords. The
Where
latest.
is the amendment? Who is appearing for this? Yes, Mr. Agarwal, where is the amendment?
Lordship, amendment is effected from September 2025. Prior to that, it was 25%, and the appeal is filed in the August. So that is being decided and rejected. So now appeal of 20 filed in August, they are liable to pay the 20%.
Please give me some dates. What is the order of the original authority?
My lord, the order in original was my lord 28/7/2025.
28/7
2025.
2025.
Yes, my lord. Then I came.
The order in original.
Yes, my lord. Then
and when did you prefer an appeal?
My lord, the appeal was preferred on 19th of September 2025.
19th of September 2025.
Yes, my lord.
Appeal filed.
Yes, my lords.
Under 107.
107, my lords, along with a pre-deposit of 10%.
And from when, at that point of time, what was the law?
It was 25%, my lords. I accept that.
25%.
Yes. But
please allow me to complete this.
Yes, sir.
25% of the disputed tax.
Yes, my lords.
Now, since when the amendment came?
1st October 2025.
1st of October 2025.
Yes, my lord.
Amendment came into force.
Yes, my lords. And the pre-deposit was reduced to 10%.
And the pre-deposit was reduced to 10%.
Yes, my lords.
Now, when the appeal was taken up for hearing?
My lords, 14/10/2025.
14/10/2025.
Yes, my lords. And the order was passed, the impugned order was passed on 17/10/2025.
Was taken up for hearing. And order passed on?
17/10/2025, 17th of October. 2025. Now, my lords, I just need to point
Please
out.
give me a minute, sir.
Oh,
Please give me a minute.
Apologies.
दोनों में चल रहा है
Now, Mr. Agarwal, only one thing. The order in original was on 27th of July 2025. And the period of limitation is 3 months. Mr. Agarwal, can you hear me?
Lordship.
So the period of limitation is 3 months.
Lordship.
So from the date of the order, 3 months takes us to 27th of October 2025. So a person has time till 27th of October 2025 to file an appeal.
Lordship.
So if that is so,
Lordship.
then in the meantime, prior to 27th of October, the amendment has come into force.
Lordship.
So whether he can take the benefit of the amended provision or not.
Lordship, I will just only simply say that when the appeal is filed, the my learned friend is filed the appeal prior to the amendment. So,
Mr. Agarwal, I appreciate.
Law says,
Yes,
the law
but
says,
yes, I
the
follow
law
your
says,
submission.
Lordship,
Law
no
says
appeal can be filed of the pre-deposit of 25%. So this the 3 months period is not applicable because a appellant, if he used to file the appeal prior to that, he has to comply the condition of 107 subsection 8. He has to give the due pre-deposit lordship.
Mr. Agarwal, one thing. Let us assume an appeal filed without a pre-deposit.
Lordship.
What are the consequences provided in the statute?
It cannot be entertained, Lordship.
Show me that provision.
Yes, Lordship.
Show me.
Lordship, I want third part over Lordship. I am appearing in other court, Lordship. I want a third part over for 5 minutes. 5 minutes.
Yes, Mr. Agarwal.
Yes, Lordship. Actually, my matter is called in court number 1 also. So that's why I take a short passover. So sorry for the
Mr.
delay.
Agarwal, please show me where is that provision?
Yes,
What are the consequences for not putting in the pre-deposit?
Lordship, give me 2 minutes time, Lordship.
Yes.
1 second, 1 second. Sir, Lordship, kindly see the 107 provision, Lordship.
Yes.
Uh, 107 5, Lordship.
Surface Act. Surface Act. Yes. Yes, 107, show me the consequences provided for non-deposit of the pre-deposit.
Lordship, 1074, the appellate authority may, if satisfied that the appellate was, this is not the appeal, after that, and 5-6, Lordship.
Yes.
No appeal shall be filed, subsection 1, unless the appellant has paid the full part, this is not relevant, provided that. Lordship, with me?
Yes, yes.
Provided that the no appeal shall be filed against the order under section 103, subsection 129(3), unless a sum equals to 25% paid.
No, no, where is that? This is, I think, it's the, where is the earlier pre-amended provision?
This is the pre-amended provision, Lordship. I am just
No, I
referring
do not
to.
have the, do you have the book? Where is the, geez, আগের বইটা কোথায়? পুরনো জিএসটি একটা নেই।
Who has executed this salary? His predecessor.
Yes, yes. Yes.
Yes, Lordship. Before the amended come to in September, Lordship, prior to that, there is a provision, no appeal shall be filed against an order under subsection 3 of 129. The case in hand is 129. So, unless a sum equal to 25% of the penalty has been paid by the appellant. And in this case, also the writ petition is agreed that if he has got the chance from the appellate authority intimating that you have paid only the 10%, he could have paid the entire amount. This is the submission of the writ petition, Lordship. So that's
No,
why, in short, what I pray.
Is it an appeal under 129(3) against an order under 129(3)?
Yes.
Yes, Lordship.
But that proviso has now been omitted.
Yes.
No, proviso is not omitted, Lordship. It is reduced to 10%, Lordship.
Yes.
The earlier provision is for 25% for penalty. Now it is 10% after by notification. 17/9/2025 is the amended provision. Appeal is filed on 28/7/2025, Lordship.
No, appeal is filed on 19/9, Mr. Agarwal.
The appeal filed on 19th of September.
Yes, ma'am.
19th of September. No, there is one thing. There is a distinction under some statutes which says shall not be entertained.
Yes,
Here
ma'am.
it says shall not be filed.
Yes, ma'am.
So now the question arises whether the provisions as on the date of filing has to be given effect to while deciding the pre-deposit, because the language is shall not be filed. There is a bar on filing. If there is a bar on filing, the law as it stood as on the date of your filing of the appeal has to be considered, not the subsequent amendment, though it may be within the period of limitation under the statute.
That is only my submission, Lordship. In the initial, I said, Lordship, I have earlier also said that appellate should give opportunity to grievances before
it's only a pre-deposit.
So yes, only in case of pre-deposit, Lordship has got the discretionary power to allow pay the 15% additional, and the appeal can be heard on merit. This Lordship has got the discretionary power. Lordship?
No, petitioner, yes.
Yes, my lords. My lords may have section 107(12).
107(12).
My lord. 107 section 12. that mandates the appellant authority, the order of the appellant authority disposing of the appeal shall be in writing and shall state the point for determination, comma, the decision thereon and the reasons for such a decision, my lords.
Yes.
The point for determination itself means that whatever contentions I have raised in the appeal, he is required to
So
consider.
if you have not deposited the pre-deposit, there is no
Yes.
necessity to
Lordship.
decide anything.
For that, my
Lordship,
lords,
it is not
That's the very
applicable, Lordship.
foundation.
no,
That's
my
the very
lords,
foundation of filing of an appeal.
my lords,
If you
in
have not
that,
complied with that, there is no 112 will come in when you have complied with pre-deposit.
my lords, that is the whole grievance that was raised before the Honorable Odisha High Court as well as the Bombay High Court. What Mr. Agarwal is saying, exactly the same contention. The Honorable High Court categorically stated that an opportunity of personal hearing stating that there is a deficiency in your appeal is required to be given to the appellant to correct that deficiency. My lords may have that judgment.
Yes, I appreciate.
I am
Now
also
I
on
am
the
giving you
same layer.
liberty. I am giving you opportunity. Please satisfy me.
Lordship.
Deposit, he is agreeing. If you deposit, I will restore that.
My lords,
I will restore that, but you have to deposit the balance 15%.
My lords,
If you are agreeable, I accept your submission that you have to be given an opportunity. I am giving you that opportunity. If you are ready and willing to deposit the balance 15, I will direct the hearing of the appeal on merits.
I accept that, my lords. I just have a small request to make, just a small request, my lords.
Yes.
My lords, in all those cases, there was no benefit of the post amendment. In my case, when the personal hearing was granted, the amendment was already made, and
So
the
there are two
pre-deposit was
things.
reduced to 10%.
There are two things. That is why I asked you if you want, I can direct filing of affidavits on this, or this can be hard. The issue is, I accept that as on the date when the appeal was taken up for hearing, the amendment has come in. The question would be, in view of the language of section 107(6), whether the law as on the date of filing of the appeal or on the date of hearing of the appeal should be given effect to. That's the legal issue. Please satisfy me on that.
My lords, in that
Language
case,
says that no appeal can be filed. So when you have filed an appeal on a particular date, you have to file an appeal as per that
I
law.
accept that, my
You
lords.
cannot say
I will
yes
pay
because on
15%.
that date you could not have anticipated what would be the change of law coming after you are
I
filing.
accept that, my lords. I will make the payment of 15%, my lords. I have a small request, my lords, that
Yes,
this appeal was filed in pursuance to the Honorable Division Bench order.
Lordship, I have already said, informed to this court that this appeal is filed by the direction of, but Lordship, now only the point is limitation of paying the 15% additional.
My lords, may I make a small request, my lord? This appeal was filed in pursuance to the Honorable Division Bench order. The Honorable Division Bench order is at, my lords, is that page, my lords? Annexure P13, my lords, which is
page.
Yes, my lords. I'm just coming to that.
145.
No, my lord, it's at page 104, my lords.
104.
105, paragraph number 18. This order was challenged before the Honorable Single Judge. Honorable Single Judge directed me to file an appeal, go for an appeal. I challenged that before the Honorable Division Bench. Division Bench also gave me the liberty to file a statutory appeal with a direction to the appellant authority to decide the appeal, since my goods are perishable in nature and they are still under the custody of GST authority. So the appellant authority was directed to dispose of the appeal within 4 weeks, my lords. So, my lords, my only contention is I am ready to pay 15%. Let this similar, my lords, order may be passed to the appellant authority to decide it in a time-bound manner, given
More
the
so,
fact
you could not have taken the benefit of the amendment when the division bench has fixed a time limit For filing of the appeal,
My lord,
that
I
time
accept
limit
that.
was bound.
No, my lord, actually what happened was that the
More
petitioner,
you make submissions, you will be in difficulty.
I accept that, my lord, I'm not making any submissions. My
Uh,
lord, I must making a request that it should be time bound.
Yes, time bound. I am directing you to put in the deposit. Where is the order passed by the appellate authority?
Appellant authority, my lord, it's at page
164.
175.
175.
Discussion and findings, paragraph number 17 and 18. Page
The-
175.
The issue. No. The issue that falls for consideration in this writ petition is whether the appellate authority could have dismissed the appeal on the ground that there was a shortfall in the pre-deposit without affording any opportunity to the petitioner in that regard, without affording any opportunity to the petitioner to rectify such defect. First up, petitioner preferred an appeal under section 107 of the CGST Act 2017, challenging an order passed under section 129 within bracket 3 of the CGST Act 2017. First up, petitioner challenged the order passed under section 129 within bracket 3 of the 2017 Act by preferring a writ petition before this, by preferring a writ petition, and the order passed in the writ petition was carried in appeal, being MAT 77 of 2025, and pursuant to an order dated September 8, 2025, passed in MAT 77 of 2025, the petitioner filed the appeal on September 19, 2025, challenging the order dated July 28, 2025, passed under section 129 within bracket 3 of the CGST Act 2017. First up, at the time of filing of the appeal, the petitioner, it is not in dispute that the appeal was presented within the time limit fixed by the Honorable Division Bench, but the same, but at the time of filing of the appeal, an amount of rupees, an amount equal to 10% of the tax paid.
Yeah, disputed tax, my lords.
10% of the.
No, lordship, it is a penalty case of the penalty.
10% of the penalty was deposited. First up, the appellate authority, by the order impugned dated October 17, 2025, dismissed the said appeal upon holding that unless the pre-deposit as required under the statute is made, the appeal is not maintainable and liable to be dismissed. Paragraph. The learned advocate appearing for the petitioner submits that the law relating to the law relating to pre-deposit was amended with effect from October 1, 2025, and by virtue of the said amendment, a person aggrieved against an order passed under section 129 within bracket 3 of the 2017 Act is required to deposit an amount of 10% of the disputed tax instead of the 20%, instead of 25%.
Of the penalty amount, Lordship.
Of the tax now, of the penalty. 25% of the penalty instead of 10% instead of 25% of the penalty.
Lordship.
First up. The learned advocate appearing for the petitioner submits that since the statute has been amended, the petitioner is entitled to the benefits of the amendment as on the date of hearing, as on the date when the appeal was entertained. The amendment had already come into force. Such submission is disputed by Mr. Per contra, Mr. Agarwal, learned advocate appearing for the CGST authorities, submit that section 107 within bracket 6 stipulates deposit of stipulates payment of pre-deposit as a condition for filing the appeal.
In case of penalty, Lordship.
Yes, কি বললাম? Is to be made and therefore the date of filing of the appeal and not the date when the appeal is taken up for hearing should be the relevant date for considering the applicability of the relevant provisions of the statute. First up. After some argument, the learned advocate appearing for the petitioner, on instructions, submit that the petitioner is willing to deposit the balance amount in case the court is ready and willing to deposit the balance amount of pre-deposit within the time that may be allowed by this court, and the appellate authority be directed to dispose of the appeal expeditiously.
My lords, may write it within 3 days. I need the earliest disposal because
Mr. Agarwal, learned advocate appearing for the CGST authorities, does not oppose such prayer made by the learned advocate appearing for the petitioner. First up, in the light of the submissions before this, in the light of the submissions made by the learned advocate for the petitioner, WPA number such and such stands disposed of by setting order dated
17th
October
October.
17, 2025, passed by the appellate authority, subject to the condition that the petitioner shall deposit the balance amount of pre-deposit.
Balance amount of 15% of Lordship.
I've said balance amount.
Yes, Lordship,
Acha,
Yes.
balance, the balance 15% of the amount of this penalty.
Pre-deposit.
The 15% pre-deposit of the 15% of the penalty.
Yes, Lordship.
Subject to the condition that the petitioner shall deposit the balance amount of pre-deposit, that is additional 15% over and above the 10% already deposited, already claimed to have been deposited by the petitioner at the time of filing of the appeal. And if such deposit is made within the time limit specified herein before, the appellate authority shall fix a date of hearing of the appeal and dispose of the same as expeditiously as possible, but positively within a period of, Mr. Agarwal?
3 weeks if possible.
4 weeks the minimum, Lordship, because we have to give some reasonable opportunity of hearing also.
A period of 4 weeks. Within a
Reasonable
period of 4
opportunity
weeks from the date of receipt of a server copy of this order.
After the payment of Lordship.
From the date of receipt of a
Payment
server
of
copy.
Actually,
Server copy of this order, without granting any unnecessary adjournment to the petitioner. Full stop. It is, however, made clear that this court has not gone into the merits of the order impugned in the appeal before the appellate authority, and all points are kept open to be decided by the appellate authority in accordance with law.
My lords, liberty may be given to me to raise the ground seeking a release of the vehicle before commissioner appeal, my lords.
Petitioner will be at liberty to
seek release of the vehicle and goods.
To move any interim application before the appellate authority in accordance with law.
And my lord, the same may be disposed of because my lords are perishable nature goods. It may be decided within 2 weeks, that in time application. Let the appeal be decided within.
If such an interim application is filed, it is expected that the same shall be disposed of expeditiously.
Within 2 weeks, my lords, may please.
Sir, you have not yet filed any application.
No, my lords,
how can
I will
fix the
file.
time?
I will file along with pre-deposit, my lords.
Lordship, in the appeal, there is no interim application, Lordship.
My lord, this is a perishable nature goods.
Lordship, kindly give me the 1 second time, Lordship.
Yes.
Lordship, the concept of appeal into the taxation system, there is no interim because once he paid the penalty amount, all he is the rest of the disputed tax or the penalty will state. So now the appeal will be disposed on merit, Lordship. So as soon as
I have not said you have to reject the application. Sir, you can file any application. You can pass orders accordingly. I have not directed you to allow that application. I have directed you to dispose of that application expeditiously. Disposal either way.
My lords may keep it for 2 weeks. I humbly request my lords, because these are perishable nature goods. At least they decided or rejected so that I can come before this honorable court.
Lordship, I will direct the appellate authority as soon as my learned friend file the application, it will be decided as early as. You file.
I'll
I,
file it now 2 weeks ka time de
as you know that I always cooperate with you.
I appreciate that, sir. Thank you.
Yes, yes.
Thank you.
I never make a trouble to any petitioner. If they are,
Thank you.
Lordship, deeply obliged.
Deeply.
Thank you.
Yes, call the list.
Matter number 18.
Yes. 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 Yes.
Covered matter by your lordship. What has happened in this matter is that there's an allegation against me that since my supplier's registration certificate has been cancelled, I am not eligible to avail ITC. However, my lord, it has been found out that my suppliers have filed their returns in GSTR 1 and 3B for the relevant period of time. So the allegation does not hold. My lord,
Yes.
um,
Where is the order under challenge?
my lord. Page 105.
105.
That
Yes.
is the appellate order, my lord.
Appeal was decided on merits or
My
limitation?
lord, it was decided on merits.
Yes.
It is very precarious to see, my lord, that I have submitted my tax invoices, e-way bills, challans, receipts for bank payments, and every other document that is required to establish a proper and a genuine transaction. However, just because my supplier is called to be cancelled dealer, my ITC was rejected. My lord, we kindly also see page number 119 to 150, where I've categorically annexed the returns in GSTR 1 and 3B for my supplier for the particular period.
100?
119 to 150, my lord. And my lord, for the same petitioner, same cause of, same facts, your lordship has already passed an order. Previously, it's just the different financial year, my lord. Same facts, my lord, same supplier. My lord, my senior will continue.
No, no, I will not permit this in that one. You are. Yes, yes. Yes.
I have filed my replies at the pre-show cause stage and at the show cause stage, where I have mentioned the details of all the documents that could have been submitted.
Yes, what is the decision which you are trying to rely upon?
My lord, an order passed by your lordship in this matter for the different financial year, same sets of facts, same supplier, my lord. My lord, both in the adjudicating order and the appellate order, the authority did not even consider my records, and even no explanation or cogent reason was given why they are bound to reject my documents, which I have produced again and again in all the show cause and the pre-show cause stage through my replies.
Yes, Mr. Bhattacharya.
Here, the main crux of the issue is this, that my supplier's RC was cancelled retrospectively. No denying of that fact. But my contention is, since he has already filed GSTR 3B, meaning paid all his taxes. So now the question cannot come that since the supplier is not there, there is no tax given, and hence your ITC has to be go down.
The order cancelling the registration has been,
My lord, that is on my supplier to do. I do not know whether they have challenged it or not. I must be very candid here.
yes.
But in all probability, they have.
But at the time when the
Yes, they have
supply
challenged.
was affected, the registration was valid.
Was valid.
Subsequently cancelled with retrospective effect.
Retrospective effect. Eradicating everything, what has been done. And that is what it shows from the GSTR 3B, that unless if he's a cancelled dealer, he cannot file his 1 or 3B. Both the returns were filed.
Yes, sure. Show me the appellate order.
My lord, at page number 105, lordship.
Yes, show me the relevant.
My lord.
107.
Yes, 107, my lord. Lordship kindly takes. Now, the relevant portion will be 112. Observations of the appellate authority. From here it starts.
Yes.
Yes. C will be very important if lordship sees. The impugned order is said as bad in law as the same was passed not considering the basic terms and conditions of the supply made between the supplier and RTP and without considering the certificate issued by the supplier. A certificate issued by the supplier Global Bitumen is found submitted by the appellant which says that the transportation cost involved were also borne by them as per delivery terms. But the goods were carried by a transporter which has no existence or business activities at all as per the report received by AO, hence the claim is not acceptable. Now the question is, my lord, transporter, whether he is present or not, my lord, how can I be saddled with such a difficult proposition? In fact, in the last occasion as well, this question was reverberated before your lordship. And lordship took the view that this cannot be a cogent ground. This is neither here nor there. No provision of the laws makes me liable for existence or non-existence of a transporter, especially when the supplier admits that he is giving a certificate. He is saying that I have sold the goods and the goods have been given to me. And also the revenue has enjoyed tax on it. Because when the supplier is saying I have sold, he is paying the tax on that.
And the transportation cost was borne by whom? The supplier.
The supplier. So the transporter was not in my payroll. Neither can I be made liable for that. And thereafter, lordship kindly turns to the next page.
Yes.
I. The impugned order is bad in law as it has been passed against the pronouncement of an identical case bearing number so-and-so Gargo Traders, where Messrs. Gargo Traders petitioners purchased goods from the same party as ours, Global Bitumen, whose registration was cancelled with retrospective effect, and ITC was disallowed by the adjudicating authority of CGST West Bengal. Honorable Court directed the adjudicating authority to consider the documents which, based on so-and-so, intended to rely in support of this claim. On examination of the facts in the instant case,
yes,
appellant has not been able to prove the eligibility to claim ITC, which is governed by criteria enumerated in section 16(2) of the GST Act. In the instant case, 2B has not been adhered to, as appellant was unable to conclusively prove with documentary evidences that the goods were actually received. Now, pausing here for a moment. My lord, what am I supposed to show that the goods had actually reached me, which is also like 3 to 5 years before? I can only show the transport documents. I can show my stock register. I can show my books of accounts. Out of that, I cannot have anything to show. Now, when I show my transport documents, they're saying the transporter is non-existent. When I'm showing my stock register, they're saying the dealer was cancelled. So this is something of an autopsy of a nature where the corpse is not available. And therefore, thereafter also, my lord, if a person's certificate of registration is cancelled ab initio, that is with a retrospective effect, the only reason is that the person has obtained that registration by some crooked means, by some fraud. Now, if that fraud has been practiced, that has been practiced on the department who has granted them the registration. I have not granted in the registration. The department has granted him the registration. I acted bona fides on it. And after checking his registration certificate, I made my purchases. Only that point of, at that point of time, only that much I can do. And what also I have done, Lordship will see my diligence, I have got hold of the copies of the GSTR 3B, which is again their document. They should have said that he has filed GSTR 3B. But now I am the person who's coming up with the GSTR 3Bs and showing, kindly see, he has already filed GSTR 3B.
The supplier.
The supplier. GSTR 3B filing means he has paid the tax. Without paying tax, no one can upload GSTR 3B. Whether it from the credit ledger or from the cash ledger, he has paid. Credit ledger, he adjusts. From cash ledger, he pays from his pocket. Now, if he has some credit, he will pay from credit ledger. Now, from how it has been paid, that is again another matter of fact. Somewhere it is paid in credit ledger, somewhere it is paid in cash ledger as well. But how am I supposed to be liable for this? I ask this question to myself. And that is the exact question. It's a doctrine of impossibility, my lord. Lordship knows way better than me, my lord. In paragraph 40, Narmada Bachao Andolan's case, Supreme Court had categorically stated that if a particular provision of law by operation becomes so inoperational that an impossibility is cast on the person concerned, then that particular provision of law has to be regarded as a directory provision of law and not a mandatory provision of law. So here also, if they go into such an airtight compartment, that is an impossibility. I have no control over my purchaser.
Yes. What do you say?
But this claiming of false ITC is revealing entire the scheme and been not paper. There are a number of criminal cases even registered. Matter pending before the Honorable Supreme Court. I fought it before the other honorable judges before.
But the fact remains that if the registration was valid of the supplier, it was valid at the relevant point of time when the supply was made.
I am not in that. Kindly appreciate the supplier place of business even non-existence. It is reflected after causing an inquiry, an investigation. Transporter place of business and transporter is also non-existent. The question is that I purchased a material from a person who doesn't have the business, the place of business shown in the portal.
Then why do not they go against that person? Why against me?
So, my lord, this is the reason, my lord, is a large-scale conspiracy, my lord. They are purchasing it by showing our documents, paying our GST only. They are not claiming a false ITC, my lord. Ultimately, the beneficiaries, my lord, is not given to the, suppose now I purchased it, that it should be delivered to the consumer. Consumer is not receiving it.
Where is the
there is no
document
findings.
cancelling the registration of the supplier?
They have not
So
given
it was
to me.
cancellation of a registration means he was registered at one point of time.
True. Oh, I'm not.
So if he was registered at one point of time, now cancellation, the date is after the supply was made.
True. Kindly.
But with a retrospective effect, that's a different thing altogether.
Kindly appreciate. I am supplying this paper from a X place of business. I don't have a place of business. From where I am running the business?
No, the question is when you have made that inquiry.
After
yes, maybe after that. So, but at the relevant point of time, we are concerned with the time when the supply was made. So, if at that relevant point of time registration was there, it presupposes that he had
business. Yes. Valid business.
He had valid business. All things were there. Now you have cancelled that. Maybe with a retrospective effect, whether that cancellation is valid or not, that's a different thing altogether. But and Mr. Bhattacharya says that he has obtained the documents of the supplier, filing the returns thereafter.
I have annexed it. I have annexed the
Which has been annexed in the writ petition also.
From page 139 to
2023, the Honorable Supreme Court said, what are the documents you have to substantiate? May I hand over?
Is it Ecomgil?
Yes.
That has got no application. I will show.
Yes, no application show.
I will show.
Yes.
Does not matter. Ecomgil का जरूरत क्या है? हम
15
यहीं से
para
पढ़ देगा.
para 15 का.
1-5.
One. একটু আমি
আচ্ছা,
পড়তে
তুমি
দিচ্ছি,
করে নাও,
আমি
করে
দিয়ে
নাও,
দিচ্ছি।
করে নাও।
My lord, first you lordship kindly see the head note. First, I'll see the head note, my lord. ঠিক আছে। Claim of in
Head note.
first head note, then my lord, I'm going to para 15 onwards.
Don't press the head note, Mr. Chu.
Then
Please
15. Then 15.
straight away come to
My
the
lord, first I
paragraph.
must come from my head. That's why there is a reason, my lord, I said
Head
that.
note is
Allah will
at
say.
times confusing.
Yes, yes, it's confusing. Yes, 15, my lord.
Yes.
Thus, the provision of section 70 quoted herein above, in its plain terms, clearly stipulate that the burden of proving the ITC claim is correct lies upon the purchasing dealer claiming such ITC. Burden of proof that ITC claim is correct is squarely upon the assessee who has to discharge the said burden. Merely because the dealer claiming such ITC claim that he is a bona fide purchaser is not enough and sufficient. The burden of proving the correctness of ITC remains upon the dealer claiming such ITC. Such a burden of proof cannot get shifted on the revenue. Mere production of the invoices or the payment made by the checks is not enough and cannot be said to be discharging the burden of proof under section 70 of that Melody Act of 2000. The dealer claiming ITC has to prove beyond doubt that the actual transaction can be proved by furnishing the name and address of the selling dealer, details of the vehicle which has delivered the goods, payment of freight charges, acknowledgement of taking delivery goods, tax invoices, and payment particulars, etc. The aforesaid information would be in addition to tax invoices, particulars of payment, etc. Now, my lord,
Now,
what is the
pausing
finding?
here for a moment, Mr. Chaudhary, without interrupting you.
My lord.
What are the documents which are lacking in this
Yes,
case?
yes,
Show
that,
me that state.
yes, my lord, kindly come 107.
107.
Yes. Exactly, my lord. You got your lordship. Exactly. Yes.
107, yes.
Now, my lord, paragraph 3.
Yes.
Bank statement in respect of payments made to global B2B page.
So payment documents are there. Yes.
Copies of consignment note, transport document issued by Messrs. Priti Road Line and Arihan Roadway, that is referred to as transporter. Upon verification of consignment note claimed to have been issued by Arihan Roadway, for the transportation of goods, it was found by AO, cost of freight was to be billed on the consignee or to be paid on the consignee. However, when Olaf Roy, authorized representative of the taxpayer, was asked to furnish proof of payment made to Orient Roadways for transportation of goods, he had stated the entire cost of delivery of transportation was to be borne.
So it was by the supplier.
Supplier, no.
Yes. So in this case, he cannot also prove the transportation charges document. It's for the supplier to prove. Yes.
Hence, verify the authenticity of transport document of the claim of the appellant. A request was sent by AO to jurisdictional office for conducting field at the declared place of business of both the transporters, Orient Roadways and PT Road Line. As for the field visit report received from the jurisdictional officer, it was discovered that Orient Roadways was non-existent, non-operational at the declared place of business, and the said transporter had claimed to have transported 4 out of 5 consignments of global B2B of appellate during financial year 18.
So this was admission.
No?
This was admission by the transporter.
No. How he has delivered?
Sir, there are two things. Now, first is, according to you, he is a non-existent transporter. You made a field inquiry. Full field inquiry was made at a point of time long after the supply was made. Maybe a person may have some business at one point of time, maybe. Now, there may be some documents to prove this transportation. One is transportation cost payment. Here it's the specific case that it's the supplier who has paid the transportation cost, not the petitioner. So he cannot produce any documents for payment of transportation charges.
But on
Second is this admission by the transporter who has admitted that he has yes, transporter has claimed.
consignment.
Yes.
He issued a consignment. He issued a consignment. It is no doubt. I'm not disputing.
No, claim to have transported the consignment. That is
That's why-
supply, movement of goods. How do you say so? Mr. Choudhury, how do you come to that finding? Because it's the admission of the transporter. He has, so movement of the goods has been admitted by the transporter.
Toll gate. But that is also we have verified. That when the car-
Show me the observations with regard to the toll gate data.
There will be same report with regards to the 50 road lines also.
All right. So if it is the same,
Kindly, just call bear. Invoice bearing number such and such dated and corresponding UAB number such and such. Order account from demand. Price charges amounting to 63,908.75 and reconciliation of payment received such and such. Cash book financial year 1920. Upon examination of these correlation of these documents below. Furnished by accountant of the said transport company, it was observed that payments as noted above had not been incorporated in the cash book.
so is it my fault? Mr. Additional Advocate General, if the transporter do not disclose the payment made by you for a transport, so whether you will be liable, I'm asking you a simple question. You have engaged the transporter for transporting a goods.
Then true, but he is not liable. But question, Miller, whether it has genuinely purchased or transported or received by the consumer, that is to be looked into, Miller. Just simply by your documents producing, Miller, it is all a manufactured documents, Miller. I am with responsibility, but I am saying all of them.
However, proved that.
No, this correlation.
Correlation cash book.
Your lordship said that yes, on a slide that the supplier shall make the payment for transportation. When it has not been reflected in the cash book, not reflected in the financial account placed by the supplier.
Do you mean to say, with such additional advocate there, all payments received by the transporters are disclosed in their income tax returns and in the cash book? I'm asking you, practical, please take a practical view. Please take a practical view. If that person transporter do not disclose that in his cash book, do not disclose that in his income tax returns, can it say, no, so that the fact that you have made payments, that can be said that.
Internally presumption.
But may I interject once?
Presumption is that, Miller, it's not way, but kindly see, it should be seen chronologically, Miller. If your lordship has seen it, then there is no place of it. Number one. Number two, Miller, subsequently it has been cancelled. I'm not coming to that. Then, Miller, the consignment EOA bill, Miller, not even correlation with that.
Show me where is that finding.
That is that EOA bill.
Where?
Invoice bearing number such and such of UA corresponding to UA number, that what we have asked for.
It was reported that the accountant of the produced the following documents
Invoice
on demand.
Yes.
Invoice and
corresponding UA bill number
so
such
this
and
was produced. UA bill was produced.
such. Originally the bill crossed the gate.
That is, Mr. Choudhury, some documents were produced. UA bill is a document, relevant document to substantiate movement of goods.
My lord, a third case is being made out. A third case is being made out.
A deed of conveyance, deed was placed with your lordship. Mutual certificate was placed with your lordship. One more thing was placed with your lordship. Does it prove? If I say genuinity of these documents is raised, it can be safely said.
Mr. Additional Advocate General, there's a presumption as to the correctness of a registered document.
Unless contrary.
Yes. So that is why I've said there's a presumption as to the correctness of a certified copy of a registered document. If you challenge the genuinity of those documents, the burden of proof lies upon the person challenging or disputing the genuineness of such document. It's in a case of that conveyance. I'm not on that. You have given that example, that is why I've replied. So, yes. So the person challenging has to, otherwise it's a general presumption of correctness of a registered document.
Yes, now that is the burden lies on. But in GHT Act, while claiming the ITC Milord, the burden lies upon the Milord, the
Person claiming.
person claim.
No dispute on that.
Yes.
Now, there are two things. What's the law of presumption? Now, the person upon whom the burden lies, he has to disclose certain documents, then the burden shifts.
Yes, for a general-
Or the owner shifts.
That I say.
Yes.
I
So
say-
he has produced certain documents with regard to the movement of goods, certain things. The supplier, he has furnished the name of the supplier. He has furnished the address of the supplier. He has furnished the particulars of the transporter. Now, with regard to the, I'm coming. With regard to the freight charges, his case is that I have not paid as per the agreement. Supplier was liable to pay. That agreement document was also placed. Now, you are trying to dispute that.
Second area that despite disclosing certain document, that document doesn't speak of that is the genuinity of the goods transported. Then my what will happen? So I'm asking myself.
My lord, may I?
So, my lord, these are this is not a case that we have 40 claims and we have reproduced in the ballot orders. We have physical verification of the jurisdictional law.
Yes, may I reply, my lord?
Then
Mr. Bhattacharya, he is making submissions. Let him conclude, piecemeal giving replies. I think then it's better that affidavits are to be filed, let it be decided.
No, my lord, no.
Has to-
Because,
because,
Lordship, only one small thing. Number one, as far as my learned friend's contention is concerned, he has already stated that as if I am hand in glove. My lord, the proceeding is under section 73, not 74. First and foremost. No, this is 73, not 74. And secondly, if there is field report, the field report should have been given to me. The field report was never handed over to me. It is a prejudicial. No. There are thousands of matters where they're invoking
Mr.
74.
Bhattacharya, this is also an appellable order.
This is the second round of litigation. This is the second round of
Maybe
litigation.
an appeal lies against this order.
Lordship will kindly see one thing. Only one small thing Lordship will see. Here,
Because all these documents, all these facts are to be considered. You have also annexed some documents of the returns of the suppliers. So they have to be given an opportunity.
this is an appeal order only. This is an appeal order only. I have come against an appeal order only.
Oh, you have challenged the appellate order.
Yes. Now, my lord, my only humble submission is this. My only humble Lordship will see. First and foremost, I'll show Ecom Gill has no application here because Supreme Court in
Let
one
them file
matter.
affidavits.
My lord, kindly. Same lordship has already passed order in 3 matters on the same petitioner with global bitumen and Orihant.
Maybe this is a different order. I have to consider.
No, lordship will kindly say. Lordship will kindly let me just place the reply to whatever my.
All right, let him conclude.
Very well.
Yes.
Very well.
Yes.
Detailed order.
Yes.
The operating part kindly come. Observations of the appellate order.
Yes.
102.
Yes.
B. The view of the appellate, the issued order of AO is bad in law and is violating of the natural justice to say nothing passed on a completely different ground rather than the original ground specified in Showcase under section 23. On the careful examination of the ground, it is seen that the matter in the case of concerning eligibility of ITC under section 60 of the Act, of whom the AO to prima facie ground of cancellation of RC of the subject. In section 16, the eligibility criteria are diverse and work in tandem. Hence, the argument is ground is not found in number 1. The improved order said to bad in-law sale was passed not considering the basic terms conditions of the supply made between the supplier and the RTP. And without considering the certificate issued by the supplier, certificate issued by the supplier, Mrs. Global Bitumen is found submitted by the applicant which say the transportation costs involved were borne by them as per delivery term, but the goods were carried by a transporter which has no accepting of business activities at all as per the report. This is the correct.
So you are disregarding the payment documents only on the ground that on a field inquiry, you have found that transporter to be a non-existent one at a point of time long after the supply was made.
What is I'm giving out of the context?
But you are disregarding a document which was produced with regard to the transport.
What is happening, here, because it is the area of all the bordering, areas.
I appreciate that, but you have to prove these facts. How can you disregard? Can you disregard a material document?
Detailed order on.
Maybe detailed. This is the reasoning.
Yes,
Reasoning, there are two things. Let us take one by one. Transport. Transport, the documents, the supplier particulars have been provided. Supplier particulars was provided. Particulars was provided by him. And it's a registered person, Mr. Chaudhary. You cannot deny that at that relevant.
How registered restriction how? There is a lot of perform. I what is the real fact?
Register it without verifying.
Yes, at the first stage, it's not possible. Because on the
It's your responsibility, Mr. Chaudhary. Law requires upon you to register a person upon making inquiry.
True. True, Millard. Millard, someone, suppose Millard, when the physical verification is made, then what we have seen, they have used my income tax PAN card, and only in the house, only a rental receipt was obtained. But actually, this is the place used for a residential purpose.
I appreciate all these, but the fact remains. But the fact remains, you are liable for, you are responsible for that.
Have made a village query, they have cancelled it. Because that is not possible, Millard. The visibility of the Millard, the challenge is that Millard first, that's why I say we are lacking on some infrastructure. We are not so equipped enough. This is the reason, Millard, these are the flaws, Millard. This is happening. But the moment, because as I said, Millard.
Now, my question to you, let us take a hypothetical case, not this case. Now a person, let us assume there was a genuine supply. Everything, movement of goods, everything. But the registration was cancelled on the ground that he obtained registration by some fraudulent means.
But genuine transportation well.
Yes. So merely because the register, so this is a factual thing. Whether the
how many ITC return claim in the year of 1890? And how many we have detected? It is not a random. We say yes, all the ITC claim can you are not eligible. Why, Mela? The court ought to have been flooded with these all vexatious applications. It is not happening here, Mela, because the officers are very competent enough, and on being detected, they are physical verification, causing investigation. They found these are the discrepancies. Then you are not entered. Not at all.
But I think a very recent decision of the Honorable Supreme Court also says that for cancellation of a registration of a supply, you cannot deny ITC. It's, I think, 1 or 2 weeks back. That's the latest
9902 of 2017. 9902 of 2017 SLP. Yes.
What is the date of the passing of the order?
The date of passing of this order is
no.
October 9, 2025. Just 2 weeks. 2 weeks.
2 weeks.
I was
1 or 2 weeks back.
I was going to refer to this only. I was going to.
So have you gone through that judgment? That judgment. That judgment has elaborately dealt with all aspects, which says, yes, for the failure on the part of the supplier, the buyer cannot be held responsible. That's the latest decision of
I was going to place that only.
That was the view taken by us in a division bench.
Yes.
But the same view is
reiterated. Yes.
Kindly appreciate. Well, because case to case basis, not every matter to be dealt. No, here what we are saying, that is a fraudulent, it is the case of.
It's saying, third case.
It's the saying. Show me your show cause.
No, 73 show cause. I'll show.
Show me the, what was the ground in the show cause?
It's 73, my lord. That's the order.
Why? Can you expand the, the proceeding initiated by issuing a show cause notice? Can you expand the scope of the,
I would say yes. Respect. You will not-
show me
Why?
the law,
Why?
show me the law that you can travel beyond show cause.
That is beyond, then another, the explanation has been sought for. That can be treated as a show cause, my lord. When a certain documents were placed on the basis of a show cause notice, certain grounds were raised, and then if we are not satisfied on the basis of the explanation given on the basis of document, then further clarification has been sought for. It's not
No.
a tantamount to a.
Show me the
No
grounds of the
further
show cause.
clarification has been sought.
Because that's the very basis. You cannot travel beyond the grounds taken in the show cause. Please show me the show cause.
Page 71, 68, lordship will see.
No, detailed document.
Page 68 is the show cause. The show cause is in a very dismal condition.
No, where is the detail? This is the summary show
My lord,
cause.
no detail was given,
No
but the
detail?
order will lordship speak for itself. Page 73, the order, adjudication
Mr.
order.
Additional Advocate General, no detailed show cause notice was issued.
কোথায় আছে কি নেই তো?
Might be not there.
No, of course not. It has not been issued. My lord, comes to page 73. Page 73, lordship comes, that's the order. That's the order of the
Maybe
adjudication.
that's the order. Where's the show cause notice? Where is the show cause notice? And you replied to the show cause notice.
Yes, where is the?
You have replied or you have not replied?
No, I have not replied, my lord.
Why?
In all probability, I have not.
Why?
I will just check. No, I have replied.
You have replied.
Yes, I have replied. I'll just confirm. Yes. Yes, I have appeared. Page 64.
No, you have appeared. I'm asking
Yes.
you, have you replied to the show cause notice?
No, because my lord, the show cause
Yes,
notice.
RP had filed one reply.
That is at page
RP had
64.
filed one reply dated 2011-2021 along with some documents. However,
However,
the
the
case
case
was
was
pending,
pending
was
for
needed
order.
for verification. In
Books of
response
account
to
were
the,
dated.
that is the, in response, the had filed a reply. Where is the show cause
My lord,
notice?
books of accounts were needed for verification. My lord, I have lordship see. So definitely in the show cause notice.
No, let me see the grounds on which the show cause notice was issued.
Well,
Where is the show cause under 73?
We'll disclose
My lord,
that.
this is the only thing that I received. Since, my lord, three matters were
Because
going
then
in
only
tandem.
thing then ought to have been
I'll tell you, lordship. Since three matters were going in tandem, probably in one they had given a detailed show cause and in others they have not.
There must be a detailed show cause
Yes, my lord, I will
notice
just check in the other matter. I will just check in the other matter because another same matter is
paid or short paid refund.
Yes.
Order.
Yes. My lord kindly takes, এটাও তো order.
So additional advocate general, please take instructions whether detailed show cause notice was issued. If this is the show cause notice, nothing. You cannot proceed against this.
Sir, I definitely that ought to have been indicated in the reply. Otherwise, if a lordship sees 74.
Yes, lordship kindly takes the other matter. They have issued a show cause in that matter.
They have issued a
So
show cause in
definitely
that
that
matter.
is
Yes,
matter also.
yes. No.
না
But
হয়নি তার কারণ দুটোই 19-20 দুটো খালি আলাদা প্রসিডিং হয়েছে দুটো ট্রান্সপোর্টারের নাম আলাদা
My lord will take 2192, WP 2192, there the show cause is there.
2192.
2192.
The next item.
It was passed over, 16.
Page
64. Here there is no whisper against me of any collusion. Detailed show cause. My lord, there are a few discrepancies Now Lordship will see discrepancy number 1 and thereafter discrepancy number 2. Your reply is found to be acceptable, page 66. Discrepancy number 3. Here the demand stays.
There, not in the detail. There. In
বলছি তো at 67 it stays. পুরোটা দেখিয়ে নি। Thereafter discrepancy
Substitute for determining on supplies made by person whose registration was cancelled retrospective.
Yes.
Only takes into account claim of ITC, global bitumen for 1920, for the purpose of.
Gautam Bishas is the other one.
But one thing can you lordship see if the two matter, they have purchased from a
This is a consolidated show cause.
that is both the their cancel certificate has been cancelled. Registration cancelled in both the
So the supplier is the same.
No. Gautam Bishas is the supplier.
Not same.
No,
And-
here
Not same.
global bitumen.
Global bitumen is Gautam Bishas. তাই তো?
Global
না,
bitumen.
হ্যাঁ, global bitumen is Gautam Bishas.
From two different persons. Not two
From
different
3 different persons, my lord.
All registrations were cancelled.
Cancelled.
I'll tell. Global Bitumen is a partnership firm. One partner's name is Gautam Bishas. The other partner's name is Narugopal Bishas. That is page 66, Lordship is seeing.
Yes.
Vinayak Bitubina.
Yes. See. Page 66, Gautam Bishas, Narugopal Bishas, both are partners of Global Bitumen. Lordship kindly turns over Orijit De. Orijit De is Vinayak Bituminous. That is the matter that Lordship was taking up.
I am purchasing B2B, all the licenses are cancelled. Certificate.
Not all. I have so many sellers, out of them 2 or 3 licenses are cancelled.
At this moment, these three before my
Now, Milord will see this such
and also place of
such a
business,
detail.
no
Milord,
existence.
such a detailed show cause
Well
notice
placed.
under section 73. Nowhere they have said that I am in collusion with them.
How?
Nowhere they have said. And Lordship
Prima
knows there are
facie.
thousands of cases of 74 going on. Nowhere they have said that it's a 74%. It's a very detailed show
So
cause
the
notice.
issue is whether for cancellation of the registration of a supplier, this ITC can
Not
be
only-
denied. That's
not
the
only
recent
for-
decision.
Not only the one reason, Miller, because I say that
May I hand
maybe
over the-
there are maybe Miller true. Your lordship is Miller.
This is the decision.
Followed from your lordship.
Yeah.
Thank you, Miller. Not only for ITC cancellation, registration cancellation. We have pointed out there are several discrepancies, Miller. তোমরা এত পড়াশোনা করে আসো কেন তোমরা? হ্যাঁ
প্রত্যেকটা
এমনিতে
শুধু একটাই বাকি আছে।
রেভিনিউ ম্যাটার বুঝি না আমি।
তোমায় বললুম দার্জিলিং চলো।
Additional Advocate General, we are online.
Sorry.
You are holding a responsible post, please, we are online. Before that, you could have said.
I tender my
anything. No.
apology. I tender my apology.
My lord, here can you see paragraph 7? Paragraph 7. We have doubted. We have doubted.
Here there is no doubt.
On the date of transaction is the important thing.
Not inversely questions have been doubted.
No.
Based, light as we find there is no dispute regarding the selling dealer being registered for date of transaction, and neither the transaction nor invoices in questions have been doubted. Based on my inquiry into their veracity, we did not find a good reason to impair. We
Milord,
made an inquiry.
Milord, the doubt has been voiced just now, here and now. Before my learned friend's pleading, there was no doubt. No doubt was there at all.
This is the
It is a
reason-
73 proceeding.
this is the
They
reason-
could have converted 73 to 74 at any point of time.
True, I-
Never did. Never did.
So, Milord,
All the
kind of
proceedings, 5
decided
proceedings
the
against
straight
me.
jacket Formula, Mela.
5 proceedings against me, all 5 proceedings, 73 proceedings. And here also the show cause says the inferences, since it's a cancelled dealer, you are not getting it.
No. This is not the only finding.
এটাই actually বাকি সব বলে দিয়েছে accepted. Last line গুলো দেখো discrepancy. Your submission is accepted, your submission is accepted. প্রত্যেকটাই বলে দিয়েছে।
Here before the Malati Honorable Supreme Court, because it was cancelled, so he is not entitled, but Honorable Supreme Court said no, he is entitled. But the question is the genuinity of the document has not been.
And it is not your case, there is collusion.
Yes.
My
Collusion.
Yes.
That
That
is
is what
case also you have not made out.
What terminology I will use, Milord?
Collusion. Nowhere you have, this collusion you have nowhere said.
Use this word, but my action for determining that the document
Fraud,
veracity of the document-
collusion,
Willful
misrepresentation, you have to make out a specific case in the so calls to so that they can reply to that. You cannot say that no.
My lord, I truly, my lord, bow down. But my lord, if your lordship
So
says
if
the-
they want, they can
the-
still initiate a proceeding of 74 against me.
we can.
They can still, even if this is set aside, they can still initiate a proceeding of 74 against me. If there is material evidence against me.
My lord, that's true at any point of time.
So,
But if your lordship sees in detailed order, we have raised certain, my lord, the doubt over the document, which
are not mine.
used
Which are not mine.
by using falsifying the documents used as genuine one.
What are those documents?
That document.
What are the documents?
Consignment notes were issued, payment was not reflected, bank account is not reflected.
That is not me again. None of
I
it
am
is
not,
me.
my lord, this is a conspiracy, my lord,
No, then why me? Why me? They can proceed against the transporter. They can proceed
What
against.
is the chronology? If all the three repetition before my lords, all these suppliers, my lord, the license or the certificate have been cancelled.
We have never proceeded against
On the
them.
ground that the place of business is not taken. In all three.
My lord, without
Because they are claiming because these are the government works, his clients undertakes. Vitamins required and they are purchasing it, false bills is being used or claiming false ITC. Because they want to show before the departments, yes, these are the quantity of vitamins used for construction of a road.
now,
Ultimately,
if I am issuing false bills, or if somebody else is issuing a false
I do
bill
not want to.
against me, then my lord, they should have proceeded against that person. They have never proceeded against them. Because from there, they will not get a single paisa. There is nothing to get against them. So they are proceeding against me.
Where, my lord, the floodgate.
These are all surmises and conjecture, my lord. All
That-
submissions
that-
of surmises and
Yes, yes.
conjecture.
Yes.
The show cause notice does not divulge anything. The adjudication order does not say collusion. Even the appellate order does not say collusion or misrepresentation.
And my lord, if your lordship see this is 2025 judgment of paragraph 7 says, my lord, clearly said. Read once, my lord. We find that there is no dispute. Honorable Supreme Court found there is no dispute regarding the selling dealer
Being registered.
being registered. That the Honorable Supreme Court found. But here what we found?
No, that may be, Mr. Bhattacharya, the second link. Neither the transactions nor invoices have been doubted.
Same here, my lord.
No, those
Same here. The invoices have not been doubted.
No, we doubt
The
it.
transporter has been doubted.
Alright, let them file affidavits. It has to be.
My lord, then one thing, so another point I would like to make. They are verily relying upon two field reports. Admittedly, those have not been given to me.
No, we'll support.
Admittedly. Why now? That will not cure that proceeding.
My lord, we could have, you could
My lord,
have
on
asked
this,
for- when-
why
when-
will I
when-
ask?
when
If
you-
something is being used against my prejudice,
you are
my
raising
lord,
this
if,
issue.
no, why will I not?
Mr. Additional Advocate General, if you have relied on some documents,
It is-
not given copies
it was-
thereof.
It is completely
then
there.
That's violation. No,
Yes.
Was placed before them.
show me.
No.
Show me.
It is reflected.
Cannot be. Mr.
Never.
Additional Advocate General,
My lord, I
is it
bow down.
sufficient?
My
Let
lord.
us assume a case. A petitioner files a writ petition, gives you a copy here and now. Ask you
I
to
have-
make. So they have to go through that field reports which you want to rely upon are to be given in advance to enable them to deal with that.
They
At
can-
the time
they-
of
they can-
hearing,
They can show any piece of paper that yes, that because in the order sheet it has been mentioned, these are the correlation which we have made. That is there. My lord, now they appear personally. Now, my lord, in the writ petition, they are.
where are the field reports? Please give copies of the field reports to them.
That will go, I mean, that will show beyond doubt.
Mr.
that there-
Bhattacharya, if I see, yes, I will give
I
you
have-
a chance. Let
I have
them file.
agitated in my writ petition as well. I have agitated this point in my writ
All
petition.
right, let them file. You want to have the copies of the
Yes,
field report?
Yes.
Let them disclose the field reports.
You will disclose in the affidavit, my lord. All detail will disclose.
Ashun. After going through the order impugned, after going through the materials on record and the order impugned, it appears that certain field verifications were made to ascertain the genuineness of the movement of goods and the field verification reports.
Field
on the
verification
field reports, what is the term?
Field report.
No, what is has been said? Field verification reports or field reports? Please check that. Field verification.
Internal investigation report, it is 100.
No, I think
I
field
will
verification
just cross check.
Please check it. Field verification reports were relied upon while passing the order impugned. First up, Mr. Bhattacharya, learned advocate appearing for the petitioner submits that no copy of the field verification reports were supplied to the petitioner prior to the field visit report verification. The field visit report was submitted to the petitioner prior to the date of hearing. So he therefore submits that
Till
there
date.
has been
Till date, it has not been supplied.
at the time of before the so he further submits that
I
till
did-
date copies of such reports has not been served upon the petitioner. Mr. Bhattacharya thus submits that there has been violation of the gross violation of the provisions of the principles of natural justice. First up, paragraph, the learned additional advocate general disputes the aforesaid submission made by Mr. Bhattacharya. First up, he submits that the petitioner was afforded an opportunity to go through was provided an opportunity to deal with such field reports. First up, let affidavit in opposition be filed disclosing the materials which were considered by the authorities at the time of passing the order impugned. First up, there shall be let affidavit in opposition be filed within 3 weeks from date, semicolon, reply thereto, comma, if any be filed within a week thereafter. Parties will be at liberty to mention this matter for enlistment under the hearing after the expiry of the time fixed for exchange of affidavits.
My lord, a stay may be granted protective.
Yes, don't take any coercive steps pursuant to this. Petitioners, no coercive steps shall be taken against the petitioner. Pending disposal of no coercive steps to be taken against the petitioner in terms of the impugned order till the disposal of this writ petition.
I'm grateful, my lord.
Others are same.
My lord,
Before your
in
lordship
16, in 16, there is no field report.
There is
In
no field
16,
report.
there is no field report. There is no allegation excepting that the dealer is cancelled. Vinayak bitumen.
2196 order holo. Yes.
2192, my lord. There, in 2192, the only allegation is the supplier is cancelled retrospectively. There is no field report, nothing on the transporter.
If that is so, that cannot be a ground only on that.
Yes. Not only the field report that we have, my lord, there is.
Verified.
Verified.
All right, come after recess.
My lord.
Affidavit, my lord.
No, my lord, there is no cogent reason for affidavit because it's absolutely pat on the point as the other matters. Here, there is no question of transportation or something like that. It is.
All right,
from-
let me see.
My lord, will come.
Detailed focus notice was, my lord, issued.
No, I'm not challenging the focus notice.
Which your lordship has seen, my lord.
I'm not challenging the show cause notice on the ground of being non-speaking.
Show cause notice.
The show cause notice is mindless. That is what I'm saying, my lord.
Details were given.
Great.
Before your lordship rises,
My lord, let me take your lordship straightway to the appellate order.
Yes.
Well, can you pass over, my lord?
Why?
Or, well, I have one content matter, item number 4. Content.
Junior is here. How much time that will take?
Content, there are 2 minutes. The moment I
The
will
junior
call,
is
my
here,
lord,
let-
leave
let
it to
him-
your lordship, I'll do.
My lord,
Yes.
yes, my lord will kindly come to page 173. Starts from 173.
Yes.
Lordship kindly comes to page 174 first.
Yes.
At the middle, bottomish middle, discrepancy number 1. Now Lordship kindly turns the page to 175. This is the identical situation in each and every matters.
175.
Discrepancy number 1 stands resolved at the 4th paragraph. Turnover and tax liability paid during FY 18-19 is accepted, and the submission of the appellant that over-reporting of tax liability of so-and-so under so-and-so had occurred is also found to be acceptable. Thereafter, again at page 76, 176, the first line, first paragraph,
So discrepancy number 1 stands resolved.
stands half of it, and thereafter whatever they're stating thereafter, in the light of the clarifications mentioned above, the submission of the appellant was accepted by the adjudicating authority. Matter is thus considered as resolved. No dues are payable.
With regard to first discrepancy.
First discrepancy completely shelved. Now the second discrepancy. Lordship kindly goes to the last line, inference. The reply is found to be acceptable. No dues are payable. This has happened in each and every case. Next. Discrepancy number 3. Here again, my lord, that list your lordship will see. As I'm talking, this is the list which is there in each and every case. They are only selectively taking up each and every, one by one, the suppliers and initiating a case. Now, Gautam Biswas and Nadugopal Biswas, this is not of this. Next page, lordship sees Orijit De at the fag end, page 178. Now, this concerns Orijit De. 179, page 179, lordship will see. Reply received, ITC availed from global bitumen, etc., etc. Gautam Biswas, the appellant then submitted another reply against the discrepancy. Appellant has reversed the ITC claim from Nadugopal Biswas and also made payment of interest in DRC 03 with reference to the ITC from Orijit De. Now the Orijit De portion comes. This is the only discrepancy out here. Orijit De is Vinayak bitumen. Now what I have submitted. The appellant was in possession of the tax invoices, e-way bills, transport documents, bank statements, party ledger, etc. marked annexure A as submitted by the RP. Thereafter, goods have been received by the appellant. Payments have been made through proper banking channel within the stipulated period of days. That the supplier has submitted all returns pertaining to the said period, which is also reflected in GST 2A filed by the supplier. GST registration of the supplier was active at the time of making such inward supply. Goods are used in furtherance of the business. Thereafter, that the reversal of input tax credit on the ground of cancellation of RC of the selling dealers, that too on a later date, further leads to payment of taxes. So these are my submissions which they have called out. Now inference.
Yes.
The RP has failed to prove the genuineness of the transactions beyond doubt. Burden of proof which is upon the appellant claiming of ITC under 155 in the following points. As per section 16(2)(c), which is enumerated as he has received the goods. Upon perusal of the submission of the RP along with the documents submitted in the support of the genuineness of the transaction, it is seen that the RP has not produced sufficient documents to prove the movement of goods and the actual receipt of the goods. Pausing here for a moment. Now, Lordship will kindly take the trouble to travel to page number 83. I should say
183.
82, 082, 82.
Only 82.
Only 82. Lordship will kindly remember the last line that I read, that the RP has not produced enough documentary evidence. Now 82 is the tax invoice, come challan. Thereafter, the next page, the next transaction, the next page. These challans and invoices run from 82 to 98. From 99, corresponding e-way bills are produced, which runs till page 105. Now 116 onwards, দাঁড়াও.
Yes.
So from 82 to 95, all the tax invoice come challans.
Yes.
From 97 till 115, all the corresponding e-way bills. From 116 to 119, all the details of the payment made through bank. From 120 to 125, the consignment notes, that's the transport documents. From page 126 to page 132 are the weighbridge weighment slips. All these documents were there everywhere. 126, 127, 128, 129, 130, 131. Then again certain road challans. These are consignment notes. Thereafter, Lordship sees the ledger copy at page 134 of Vinayak Bitumin. Then at page 135, the actual invoicing and the detail from the tally copy which is uploaded in the return. 135. 136 shows the postal trackings, which shows the receipt of these documents. So now, again coming back to page 180. So these are the documents which I have produced, and upon that only these 4 lines are spared, that as per section 16(2)(c), he has to receive the goods upon perusal of the submissions of the RP along with documents submitted in support of the genuineness of the transactions. It is seen that the RP has not produced sufficient documents to prove movement of the goods and the actual receipt. Now, my lord, I am at a loss to understand what else would I have given. Thereafter, Lordship kindly sees blind, misconceived application of ecom-gil. In this context, my lord, I'm at page 180, last but one paragraph.
Yes.
In this context, the adjudicating authority has relied upon the judgment passed by Supreme Court. Now, my lord, tarrying here again for a moment, he is the appellate authority. He has blindly quoted the observation of the adjudicating authority, quoted my submissions without getting into anything, goes into a case law. The merits of the case goes down the drain, goes into a case law. Ecom-gil. What has Ecom-gil stated? Now he is paraphrasing Ecom-gil in point 9.1. Honorable Court has held that the burden of proving of that the ITC claim is correct lies upon the purchasing dealer claiming ITC burden of proof. But I will not trouble your lordship with this because these have already been parroted. Now, next page 181. Now his inference. First paragraph, the first complete paragraph. The dealer claiming ITC has to prove beyond doubt the actual transaction which can be provided by furnishing the name and address of the selling dealer, details of the vehicle, which has delivered the goods, payment of freight charges, acknowledgement of taking goods. No, my lord, this shows how he has never applied his mind. How can I show freight charges payment if I am not paying that transporter at all? I ask this question to myself. Thereafter, the aforesaid information would be in addition to tax invoice, particulars, payment, etc. Now, my lord, pausing here for a moment, Ecom-gil. Ecom-gil has been misconceivedly quoted before your lordships many a times. Lordship, I am beseeching my lord to take Ecom Gill once for a moment. Ecom Gill. Last time, my lord, my learned friend had handed over a copy of Ecom Gill to your lordship.
Yes.
Yes. My lord, I am at paragraph just before paragraph 9.1 or 8.1. Kindly takes paragraph 7.4.
7.4.
7.4. Huh?
There is no 7.4. 7 is the only paragraph. There is no 7.4. There is 9.4, but there is no 7.4.
Lordship, may I take your lordship to paragraph 6? Lordship is Sri Nikhil Goyal, learned AAG appears. The state has vehemently submitted the facts and circumstances of the case.
Has appeared on behalf of the state road? Yes. Paragraph 8. Yes.
Yes. Yes, the High Court has materially erred in dismissing the revision applications and confirming the respective orders passed by the appellate authorities in allowing input tax credit in favor of the purchasing player. Now, my lord, lordship knows way better than me. Before applying a judgment, it is very necessary to see the facts under which it has been passed. Now, when the assessing officer doubted the genuineness of the transactions or sales, and when it was found that the sale transactions were only paper transactions, and even in some of the cases, the registration of the sellers were cancelled and nothing was on record that tax was paid by the seller, the purchasing dealer shall not be entitled to input tax credit. My lord, unfortunately, this pillar has never been canvassed. I am hinging my case on 2 points. Number one is this, that where there is no allegation against me, and second, where the tax was paid by the dealer. Here the tax was paid, GSTR 3B was filed in all these cases. Ecom Gill cannot have any application whatsoever. The appellate authority is blindly applying Ecom Gill. Even in the appellate order, my lord, blind application of Ecom Gill. Ecom Gill has said this, you should have to proceed in accordance with Ecom Gill. Why? Am I those dealers who were indicated and implicated in Ecom Gill? Here my seller has paid the taxes.
Yes.
Thereafter, I am skipping 3 paragraphs, my lord. 4 paragraphs. We have heard the learned counsel for the respective parties at length. My lord has got it.
Yes.
We have gone through the orders passed by the assessing officer and the first appellate authority, as well as the orders passed by the second appellate authority or tribunal, and also the impugned judgments and orders passed by the High Court dismissing the revision application. The respondents herein, all purchasing dealer claimed the input tax credit on alleged purchase made from respective dealers. The assessing officer, on appreciation of evidence and considering the other material on record, doubted the genuineness of the transactions and the purchases made from the respective dealers and denied the ITC. The findings of fact recorded by the assessing officer came to be confirmed by the first appellate authority. However, the second appellate authority and the High Court have allowed the ITC by observing that as the purchasing dealers produce the invoices issued by the respective dealers, that is, in some cases, they also made the payment through checks. The assessing officer was not justified in denying the ITC against the grant of ITC, the state before this court. Therefore, the short question is posed for consideration whether in the facts and circumstances of the case, the second appellate authority as well as the High Court was justified. Now, my lord, this phrase, in the facts and circumstances of the case, there they had not paid. Here my suppliers have paid. There the assessing authority and the first appellate authority unequivocally recorded that the transactions were fraudulent. And here, on the contrary, they have issued by way of section 73, which is a provision for short payment upon mistake and not a short payment upon fraudulence. So, Ecom Gill cannot have any application whatsoever in this matter. And the collusion point is for the first time taken up here before this honorable court, trying to be made out a third case. The revenue had never ever stated this. I will put the assessment order as well, the adjudication order as well. These are all true, and my lord, this was given, this order, this judgment of Ecomgil was pronounced for a VAT matter pertaining to the year 2014, when online things were not in vogue. And that is why all these documents were needed to be produced. The waybill was not electronic at that point of time. The waybill had to be sealed and stamped at each of the checkposts. And now checkposts have been done away with. There are no checkposts at all. So the very concept we are here trying to, my lord, Lordship will not take me amiss, my lord. We are trying to compare a spade with a pen. The things are completely different. And now coming back to my impugned order, page 181.
Yes.
Further, the adjudication authority also replied upon the judgment, again from one judgment to another, now to Allahabad High Court. Let us see the judgment. In the case in hand, the petitioner has only brought on record tax invoices, e-way bills, party ledgers, payment through bank channel, but no such details as payment of freight charges. My lord, at page 181. Yes. Payment of freight charges, acknowledgement of taking delivery of goods, toll receipts, payment thereof. Now, my lord, when I am showing payments, they are saying you have not produced toll receipts. How can I produce toll receipts? My lord, I ask this question to myself. I am not the driver, not the helper. I am not in charge of the vehicle at all.
Yes.
Thereof has been provided. Thus, in absence of these documents, so and so transactions cannot be established. So where is the application of mind of the appellate authority? True, it is a 100-page order, but he has only parroted the observations of the adjudicating authority, my submissions, and 2 paragraphs, writing 2 judgments, quoting 2 judgments without entering into the merit of the case. Thereafter, annexure 2, interest payable. Now the interest calculation has been done, and thereafter, now Lordship will see on the next, another page 182, inference, submission is accepted, no further dues payable. This is the reversible charges. Thereafter, discrepancy number 4, again, submission accepted, no further dues. Now computation, now again grounds of appeal they have stated, and in this ground of appeal, they have stated many things, but I will go to the cut short the matter, my lord. Page 184, Lordship kindly takes. Moreover, the government has provided the mechanism of matching input tax credit with GSTR. The assessee had complied all relevant provisions. My lord, he is citing from my submission. To avail the input tax credit as mentioned in under so and so, assessee is in possession so and so and so, all these done. Paragraph 6, the impugned order is bad in law. I do not know why they have cited all these things. They have simply cited it. There is no consideration. Then again, Lordship kindly turns the page, that the impugned order is bad in law. Obviously, the appellate authority will not say this. These are my submissions. That the impugned order is bad. Now, 185 fag end at the end, page 185, on the facts and circumstances of the case, and in view of the legal provision cited above, appellant challenged the order of adjudicating authority and thereby filed the instant appeal. And thereafter, on going through the order of the adjudicating authority here, referred to the impugned order so and so, on going through the grounds forwarded by the appeal, come across following facts. The grounds of appeal put forward by the appellant are without any material substance and any support. My lord, I again pause here for a moment. The assessing authority, the appellate authority, my lord, if I do not know whether I have missed something or not.
When the supplies were made?
September 2019.
September
2019.
All.
I will give the exact dates. I will give the exact dates. अरे कोথায় कुछ नहीं लिखा है सब কটা ডকুমেন্ট রয়েছে এখানে कुछ नहीं लिखा है September 2019, September 2019, August 2019, July 2019, June 2019, May 2019.
Where are you getting that?
Page 82. 82. 82.
No.
From 82.
Tabulated here. Or you have stated the dates?
I have given all my tax invoices.
All right. So it is for the
period April to September.
Supplies made between
April to May to September, 31st May 2019 to 23rd September 2019.
To September
May to September, 31st May
2019.
To 23rd September 2019.
These are supplies made by Arijit De.
These are supplies made to Arijit De.
By Arijit De.
By Arijit De to me.
Yes. When the registration of Arijit De was cancelled?
My lord, that I cannot say because this was cancelled after 2020 because that is a coveted information between Arijit De and the department. I do not have any inkling to that. But at that point of time, I have dealer's portal's screenshot and the invoices also show that he was a genuine dealer at that point of time. It is their contention, they have cancelled him.
Yes.
And all these things have happened and Arijit De's GSTR 3B is also there. Lordship kindly sees. It is annexed.
Yes.
Dhana na baba. Eto thorfor korle mamla hoy. Page 192. Lordship sees page 192. He has filed all the GSTR 3B. Filed 192, 193. He has filed for all these relevant periods. So if he is filing GSTR 3B, he was obviously a dealer who's present and active. And again, GSTR 3B filing means paying taxes.
Yes.
Page 192 and 193. Now, my humble submission is only this, my lord. What else could have I done? This is my only question to myself. What else could have I done?
More.
My lord, that is all.
Yes. Show me the reasons assigned by the appellate authority.
Yes. 181, my lord, kindly.
181, yes.
181. Yes, 181. For that, the 180 my lord, page, the inference has been dropped. Page 180.
180.
Inference, the, my lord, can you see the inference in bold? It's just
Yes.
the RP has
This
failed
is
to-
with regard to this discrepancy.
These are not his inferences. This is adjudicating authorities' inferences, which is quoting. Page 174 will speak.
Yes.
This is not appellate authorities.
All right. Yes.
The appellate authority or the adjudicating authority, which has been reviewed, the appellate authority say this is the discrepancy on the basis of the record document that has been reproduced. So this has been discrepancies found. Now page 181, my lord, kindly turn. The second paragraph. 181, next page. Second paragraph. It starts with in the case in hand. Lordship, got it?
Yes.
Now, my lord, in the case in hand, the petitioner has only bought on record the tax invoices, UA bills, party ledgers, payment through banking channel. But no such details as payment of freight charges, acknowledgement of taking delivery of goods, toll receipt and payment thereof has been provided. Thus, in absence of this document, the actual physical movement of goods and genuineness of transportation.
Do you have a copy of the Allahabad judgment?
Right now, I do.
Because this is not the finding of the appellate authority. This is the quotation from the Allahabad judgment, paragraph 15. Please see the previous paragraph. Further adjudicating authority has relied upon the judgment in the case of such and such. In point number 15 of the judgment, the court held as follows. That was the observation of the Allahabad High Court in that judgment. This is not the finding of the appellate authority.
No, Miller. In the case in hand.
That's, please see the previous sentence.
This follow.
Show me the Allahabad judgment. That was the facts of that case. Cannot be the finding of this judgment.
Then Miller, kindly then straight away come to 186.
Yes. Yes.
Miller 186.
Yes.
From records, Miller, paragraph 3.
Yes. So this is the only finding.
Miller, I am coming.
Paragraph 3 and 4.
Miller, I am coming. Paragraph 7, then read.
No, you can place paragraph 3 and 4.
From records, it was found that the registration certificates, some of the suppliers as detailed in the order of the adjudicating authority from the appellant has made purchase or found cancelled. That is Gautam Bishwas, with effect from the 30th.
That is with effect from. The date of cancellation has not been mentioned.
That
Yes.
it has to be
Retrospective effect.
definitely. But he has purchased it into what he said on the challan in 2009.
19. But the date of cancellation is relevant.
Date of cancellation.
Yes.
It has not been there.
So what is the date of cancellation?
I actually look because this
Has to be after. Has to be after.
all right.
Because there is no finding, because the appellate authority recording with effect from has not recorded purposely the date of cancellation.
Maybe.
Yes.
But it is we cannot without verifying the record. I cannot tell you. Tell your lordship that when actual date of cancellation. Then the all three which they have purchased, Gautam Bishwas, Tharu Gopal and Purijit De, all in 2018 and 9.
Yes, he said admittedly in 2019, that is after
From the
12.
documents.
Yes, 12/10/2018.
I am admitting because I can't deny at this juncture.
Because this is your order. Yes.
Till 7, paragraph 7.
Yes.
The appellant was offered 4 rounds of reasonable opportunity of being heard. At the appeal stage, then date was given. I'm not. Despite. Paragraph 7. Despite offering such multiple opportunities for hearing and to submit submission, rebuttal, etc., the appellant on each and every occasion avoided the hearing opportunity by seeking adjournment in the online through GST portal. As detailed and discussed herein above, though multiple hearing opportunities were provided, the appellant has failed to respond to the matter. No any detailed submission with substantial supporting document in compliance to corresponding provisions of law or any objection, etc., has been submitted by the appellant. The appellant has also failed to appear for hearing in all the above mentioned dates fixed for hearing or to put forward any submission of objection, etc. On the basis of all above discussed details and circumstances, in absence of any substantial supporting document and in absence of any representative on the part of the appellant to cross-verify the claim and stand of the appellant as detailed and claimed in the statement of fact and grounds of appeal, and the appellant fails to appear for hearing, this appellate authority is left no other option. Under all above discussed circumstances, in absence of the substantial supporting documents. Now, what are the substantial documents, my lord, which I intended to, my lord, at page 181 that your lordship says from the judgment, Allahabad judgment follow. Actually, my lord, it is said in the case in hand. My lord, in recording, I
Case in
understand.
hand, it's point number 15. That is why I want to see the judgment. It is quoted.
Yes.
Made by the was not for the reasons mentioned above.
Similarly, in this case,
Because Mr. Chaudhary, please, have you got
Paragraph 50.
it's quoted? Has to be.
yes,
Because thus, in the absence of those documents, the actual physical position as well as cannot be assessed. As such, the submission made was found not acceptable.
my lord, yes.
I know.
Yes, please check up. Same thing, quotation. Paragraph 15 of that judgment.
Yes.
It's not your finding here.
Not, but that same, my lord, same document.
But you have to arrive at a finding.
My lord, true.
This is not your finding. This is the quotation of
But
the Allahabad
my lord,
judgment.
But my lord, if your lordship draw the
Yeah.
inference that the findings that
But
despite,
that is, I cannot draw any inference when you do not have any finding on that.
but
You have to
despite-
apply
But despite the opportunities were given,
the only reasoning, Mr. Chaudhary, is page 186, paragraph 3 and 4. That's the only reasoning in a longish order, spanning about how many pages?
So
I think 8-10 pages.
187.
Only one paragraph.
170 to 187.
Show me
50
the
pages.
adjudication order.
Yes,
But
yes.
Part Miller, despite that, if they have chosen not to appear, not to disclose the document, which has been
No,
allowed.
the other
But if
thing
the
is that
document cannot-
138.
the documents which were produced, this page 82 onwards, which
Yes.
Mr. Bhattacharya relied
Yes,
upon,
yes.
this was not produced before.
All.
Are you denying these documents were produced before the adjudicating authority?
It was the-
They have accepted in the order itself.
Yeah, but query from the honorable court, let me answer.
Yes.
Malad, these are the documents which were placed at the time of filing the appeal to online portal.
Yes.
These documents.
So you could have verified that.
No, in addition to that, without certain other documents required, whether the goods were actually transported or not.
These are the documents. Did you consider these documents? Please show me the findings that these documents considered do not prove those. Show me one line of your finding.
Page 72 will show. Malad,
This
page
has to
72
go.
will. Page
Mr.
72 will.
Chaudhary, this order has to go.
Malad, may I suggest-
3-line
May I-
finding
Malad,
has to go.
may I suggest, Malad?
Page 72
Because-
shows.
My suggestion would be definitely subject to your what you like. That the authority could not tally with the document. I am taking on my shoulder. I am taking on my shoulder. I could not, I did not. Right? The authority could have asked him to produce these documents they have. From the record, I can't get. So, Miller, all these documents, let them go back. Let them consider in detail, Miller.
Yes, yes.
I will instruct my officer not to copy or to. I will do that. And
It's an order.
When I cannot substantiate, which is not reflected in the order. And I do not, Miller. I do not.
And one thing, Mr. Bhattacharya, why did you not appear?
I
before the
appeared. Page 72 will disclose.
Oh, it has been recorded multiple hearing opportunities.
My lord, I
failed to respond.
I'll tell you, lordship, what happens. Even my learned friend will be at one with this. In the GST portal, whenever the notice comes and we reply, it is automatically ticked that we do not, no personal hearing required. There is a line and there is a checkbox which is already checked. Now, many a times it happens that the reply is sent and even the assessee does not take into account that the reply is already checked.
No. That's what I'm not on that. I'm not saying that you have not filed those documents, not replied to. I'm asking you why you did not appear at the time of hearing.
I'll tell you, lordship, 4 or 5 proceedings were going on at tandem. We have appeared in all of them. Maybe in this matter, nothing new was there. So it is an arrangement.
Maybe,
very well. I take that. I take that. I take that, my lord. I take that because if yes, he should have been diligent. I take that back. He should have been diligent on that.
In the petition, that despite I have appeared, it has been reflected wrong.
No. That is not my case. Why will I? That
because
is
in the order,
Yes.
Mr. Chaudhary, you will find that he records his submission wherein it has been stated that these host of documents
Yes.
have been filed.
In the last day, he was not there.
Considered that.
This is the reason, Millard, I say.
Yes.
Because correlation of the document. Suppose now, Millard, I have supplied a document. Now, the moment after the appellate authority thought that I need a correlation, that correlation he did not get an opportunity to.
That is a different thing altogether. Ashwin.
Like page 72 will show that I have submitted all these documents.
No, I'm not denying at the time of appeal.
Yes, yes.
I'm not, because it is reflected. What?
I can pass this same order if lordship wants to. This is your lordship's order in another matter. In this assessee's matter only.
দিয়েছো কোথায় নাকি আসেনছি
তাহলে আমি একটু পড়ি আমারটাই দিয়ে দিচ্ছিলাম তোমার
Here it's the appellate authority.
Appellate and adjudicating, both, because the adjudicating authority has also never considered. I have produced the same sets of document to you.
Yes, but that
And
was, I think,
another
You have challenged the order of the adjudicating authority.
Here also, I have challenged adjudicating authority's order.
Here
And
after the appeal, I think they are only.
no, both after, because that will bar me from having an alternative remedy, my lord. There also I have challenged both. The first page of the order, my lord, it records.
Oh, yes, appeal.
Appeal. Because, my lord, what happens under the GST laws, the appellate authority does not have the power to investigate. If they want to investigate, the assessing authority will be the perfect authority.
This application under Article 226 of the Constitution of India is at the instance of a registered person under the West Bengal Goods and Service Tax Act 2017 and is directed against the appellate order dated May 16, 2025, passed by the Joint Commissioner, State Goods and Service Tax, Siliguri Circle, State Goods and Service Tax Appellate Authority, Siliguri Circle, Siliguri. Full stop. Thereby affirming the order of the Assistant Commissioner, thereby affirming the order of the Assistant Commissioner, State Goods and Service Tax, being the adjudicating authority, Siliguri charge, Siliguri, dated August 29, 2024. Yes. Paragraph. Where is the order of the adjudicating authority?
My lord, at page 89, 130s.
Page?
138, my lord. 138.
কি বললাম last time? First paragraph. Show cause notice under section 73 within bracket 1 of the WBGST Act was issued, alleging that certain discrepancies were found upon examination of the returns filed for the financial year 2019-2020, and the petitioner was asked to pay tax, interest and other amounts arising from such discrepancies, or furnish an explanation for the discrepancies mentioned in the said notice within the time limit indicated in the show cause notice. Petitioner duly submitted reply to the said show cause notice Full stop. The proper officer, being the adjudicating authority, passed an order under section 73 within bracket 9 of the WBGST Act, thereby the adjudicating authority also held only in respect of one discrepancy. Where is that? Which page?
My lord, page 138, the discrepancy your lordship will see.
Discrepancy 1.
1 is resolved. 2 is also resolved.
3 is only the material.
3 is, yes, 3
Three.
is the only material.
কি বললাম? The dated করেছি, dated January 19. No, what is the date? Dated August 29, 2024. Full stop. So, 4 discrepancies under serial numbers 1, 2, 3, and 4 were mentioned in the show cause notice, but the adjudicating authority, after considering the reply to the show cause filed by the petitioner, accepted the reply insofar as the discrepancies under serial number 1, 2, and 4 are concerned. Full stop. With regard to the discrepancy under serial number 3, the proper officer held that the petitioner failed to prove the genuineness of transactions beyond doubt and determined the amount of tax, interest, and penalty. Full stop. Being aggrieved by the order dated August 29, 2024, petitioner preferred an appeal before the appellate authority under section 107 of the WBGST Act 2017. Full stop. The appellate authority passed an order on May 16, 2025, thereby dismissing the appeal. Passed an order dismissing the appeal, thereby affirming the order passed by the adjudicating authority. First, the issue that falls for consideration is whether the appellate authority was justified in affirming the findings of the adjudicating authority in respect of the discrepancy pointed out. Discrepancy pointed out under serial number 3. The after going through the discrepancy number 3, it appears that it was alleged that the petitioner availed input tax credit within bracket ITC on supplies made by persons whose registration was cancelled retrospectively, and that such ITC is not admissible under section 16 of the CGST and WBGST Act 2017. Full stop. Paragraph. Petitioner claims to have submitted various documents in support of his contention that the purchase made by the petitioner was a bona fide one, and there was actual physical movement of the goods from the supplier to the petitioner. Full stop. Petitioner claims to have submitted various documents, namely tax invoices, e-way bills, transport documents, bank statements, party ledgers, etc.
And payment slip as well.
Party ledger, payment slips, etc. First up. Petitioner claims to have made payments through proper banking challans within the stipulated time limit. Full stop. The petitioner claims that the GST registration of the petitioner was active at the time
Supplier.
of making
Supplier.
Sorry, GST registration of the supplier was active at the time of making such inward supply, and also that the goods were used in furtherance of the business. Full stop. Paragraph. Petitioner has also annexed the documents in support of his contention that the transaction was a bona fide one in this writ petition. Full stop. After going through the order passed by the appellate authority, this court finds that the appellate authority noted the submission of the petitioner, noted that the petitioner has submitted various documents. Full stop. Paragraph. Mr. Bhattacharjee, learned advocate appearing for the petitioner, submits that the appellate authority, without considering the materials available on record, rejected the affirmed the order of the adjudicating authority only on the ground that the invoices were issued after the date of cancellation of the GST registration of the supplier.
Effective
After the effective date of cancellation of the GST registration of the supplier. In support of his contention that retrospective cancellation of GST registration of a supplier cannot be a ground for denying the input tax credit to a purchaser. He placed reliance upon the decision of which decision?
My lord, this is Shamolmoy Pal, bearing WPA number.
He placed reliance upon a decision of this court, placed reliance upon an
This is a
order
reported
dated-
judgment, my lord, but I do not recollect the
This has been
reporting.
reported.
Yes. It's a reported judgment.
Places reliance upon an order dated April 8, 2025, passed in WPA 708 of 2025 in the case of Shamolmoy Pal versus Assistant Commissioner of State Tax, Siliguri Charge and others. Full stop. He submits that the appellate authority mechanically affirmed the order passed by the adjudicating authority full stop. Paragraph. The learned additional advocate general submits that in spite of repeated opportunity of hearing being provided to the petitioner, the petitioner did not attend the hearing before the
Personally.
did not appear for personal hearing before the appellate authority. Full stop. He submits that the burden of proof lies upon the person claiming input tax credit to substantiate by production of material evidence that the transaction was a bona fide one and there was actual physical movement of goods from the supplier's end to the purchaser. He submits that the appellate authority, after considering the materials on record, passed a detailed order, and this court should not interfere with such order in exercise of the powers of judicial review. Heard the learned advocates for the parties and perused the materials placed. After going through the order passed by the appellate authority, this court finds that the appellate authority has recorded that the petitioner has submitted various documents, namely tax invoices, e-way bills, transport documents, bank documents, party ledgers, etc. After noting the contentions raised by the petitioner, the appellate authority took note of the findings of the adjudicating authority and without assigning any reasons as to why the documents produced by the petitioner cannot be said to prove the genuine transaction and actual physical movement of the goods from the supplier to the purchaser. affirmed the order of the adjudicating authority only on the ground that the invoices issued by the supplier from whom the petitioner has made purchases and has claimed ITC, the invoice dates were found. No, the invoices were found to have been issued after the date of cancellation of the registration certificate of the above detailed suppliers. Full stop. After going through the materials on record, this court finds that in the show cause notice, the where is the show cause notice?
Page 70, 67. No, order.
64.
61. 60.
Show me that relevant.
No, 64. Yes. Lordship will take page 66.
Page 66.
6. ITC found reversible. In the middle. Discrepancy number 3.
Discrepancy number 3.
3
is 2.
66, my lord. Page
Yes,
66.
66.
Discrepancy number 3. ITC found reversible on count of various reasons.
কি বললাম? Now, after going through the show cause notice, this court finds that it was alleged that the petitioner had availed ITC under CGST and WBGST Acts on supplies made by persons whose registration was cancelled.
Only one person here.
Was made by person whose registration was cancelled retrospectively.
Yes.
Full stop. Though the effective date of cancellation of the registration of the GST registration of the supplier in question, namely Origin Day, is prior to the date of issuance of the invoice, but it is not in dispute that the GST registration of the said supplier was cancelled after the issuance of the invoice date, but with a retrospective effect from October 12, 2019. It is not the case of the revenue that as on the date when the supplies are claimed to have been made by Origin Day to the petitioner, the registration of the supplier was not in force, was not valid. Full stop. It is now well settled that retrospective cancellation of registration of the supplier cannot be the sole ground for denying the income tax credit.
Input tax.
Sorry. Input tax credit, always I mention as income tax credit. Input tax credit to the purchaser. Full stop. Apart from holding that the invoice dates were after the effective date of cancellation of the registration of the GS date of cancellation of the registration certificate of the supplier in question. No other ground has been mentioned by the appellate authority as a ground for denial of input tax credit.
Adjudicating authority as well.
Full stop. Appellate authority is affirmed, so it's the appellate authority now. Full stop. Though it is not in dispute that's on a query of the court, Mr. Bhattacharjee, learned advocate appearing for the petitioner, submits that several proceedings against the petitioner were pending at the relevant point of time, and the date of hearing fixed by the appellate authority insofar as the instant case is concerned somehow escaped the notice of the petitioner, for which the petitioner could not attend for personal hearing before the appellate authority. Even if the appellant is not present at the time of personal hearing, and the documents in support of the appellant's contention are all on record, are available on record, it is the duty of the appellate authority to consider such documents and return a finding on such documents. Even if the contention of the revenue is accepted that the petitioner failed to attend the personal hearing in spite of being afforded several opportunities in that regard, the appellate authority, to the mind of this court, the appellate authority failed to perform its statutory duty by passing an order mechanically affirming the findings of the adjudicating authority without considering the materials available on record and the decisions which were relied upon by the adjudicating authority while passing the order of adjudication. First up, since for all the reasons as aforesaid, this court holds that the appellate authority, this court holds that the order impugned, the order passed by the appellate authority is a non-speaking order, and only for such reason the same is liable to be set aside. Full stop. Accordingly, the order of the appellate authority dated May 16, 2025, insofar as it relates to discrepancy under serial number 3.
That is the only order.
If I set aside everything, goes set aside, everything will revive.
I got the benefit.
That will also revive.
Adjudicating order. In the adjudicating order, I got.
So everything will revive. Ivallam? Under serial number 3 is concerned, is set aside. Full stop. The appellate authority is directed to fix a date of hearing and to serve an advance notice to the petitioner full stop.
Lord, only subject to correction, Lord. The appellate authority will have no power to investigate. So if it is the appellate authority, I have no qualm. But no new investigation or anything cannot be done by the
I'm
appellate.
only directed the appellate authority to decide the discrepancy number 3. I'm not making any observations.
Very
Exercise is
Kyolo.
very good.
leave it to the appellate.
And to serve an advance notice to the petitioner. Full stop. The appellate authority is directed to dispose of, to pass a reasoned order insofar as the discrepancy number 3 is concerned, after giving an opportunity of hearing to the petitioner or his authorized representative. Only the issue number 3, because others
Only
need
issue
not
number
be
three.
otherwise.
Yes, only. Any direction, period is
Post
given.
off with your
Specific period is given.
If you want, I can fix
Leave it. At the earliest. We'll do
as
that.
expeditiously.
Yes, yes.
বলেছি তো as expeditiously. Dispose of. ওটা ওনাদের হাতে, যত তাড়াতাড়ি করবে, না হলে করবে না, পাবে না টাইম।
The affidavit of service.
এভরি সার্ভিস কিছু এক্সপেডিশিয়াসলি লিখতে হবে না, এমনি এক্সপেডিশিয়াসলি করবে। Yes.
Grateful to my Lord.
Yes, call the next matter.
19 টা 20 কি করবে?
Yes.
20.
19. Yes, 19. What is 19? Who is appearing? Yes. What do you want?
19, Lordship, action on the part of.
Who's in action?
Police authority.
Lordship, kindly fix the matter on 6/11 because our returnable date is 6/11/2025.
What are you doing? To lodge FIR on the basis of the written complaint. Consider this and pass, take a decision. If it discloses a cognizable,
We did not receive any instruction. Lordship, till date we did not receive any instruction because
if it discloses
they-
cognizable offense, you register a FIR. If it does not disclose a cognizable offense, the
কি হলো?
I thought
No, no,
Lordship was
বলো
keeping
যেটা
it on. I thought Lordship was keeping it for 6th. Lordship is passing out in the.
she is entitled to an adjournment, but now she is agreeable.
Yes, sir.
The petitioner alleges.
I'm for the private respondents, Lordship.
Yes.
Lordship, kindly, if a report may be called for and the date petition may be.
Why? Why report? The petitioner alleges
Lordship, because we are the workers of the tea garden. Lordship, we are not being paid our due. The garden has been kept like that, Lordship. Lordship, kindly let the writ petition be kept pending and a report.
they have made a complaint. Where is your complaint?
Yes, page 18 and page 19.
Page 18 and 19.
Yes, page 18 is the specific complaint to the.
If you have any complaint against the owner, you are free to make a complaint. The petitioner alleges that no steps have been taken by the police. No steps have been taken by the police authorities to register an FIR on the basis of the complaint lodged by the petitioner on September 20, 2025.
Yes, Lordship.
Full stop.
Subsequently, I made another letter to the superintendent of police and to other state machinery, that is the district magistrate.
Sir, 2 FIRs cannot be
No,
registered.
only one.
So which one do you want?
18, Lordship. That is the.
Full stop. Paragraph. The learned advocate appearing for the state seeks an accommodation to take instructions from the concerned respondent. Full stop. However, since a complaint has been lodged with the officer in charge, Nagrakata police station. It is the duty of the police authority to register an FIR if the complaint discloses a cognizable offense. Full stop. WPA number such and such, আচ্ছা তারপরে লিখুন, the learned advocate appearing for the private respondent submits that the private respondents are the workers of the tea garden and they have not received payment for how many months?
This submission I am disputing, Lordship.
That they have not received payments for a long time.
I am disputing.
First
this
of such submission is however disputed by the learned advocate for the petitioner. First of, in the event the private respondent has any grievance against the petitioner, it will be open to the private respondents to ventilate such grievances before the appropriate authority in accordance with law. First of, WPA number such and such stands disposed of by directing the officer in charge, Calcutta police station, to consider the complaint lodged by the petitioner on September 2025 and to take steps on the basis of such complaint in accordance with law. All right, কি বললাম? To take steps in accordance with law if not already taken. Yes, thank you. Disposed of. Next.
5 minutes matter, Lord, this one.
Let it be remanded. back
Yes,
to
yes,
the,
yes. Yes. What has happened, I'll tell you, Lordship, it's a RCM claim, revenue neutral matter. Yes, revenue neutral matter. Let them look at the claim. Let them look at the claim.
What claim?
My lord, here is a reverse charge mechanism.
No, no.
I have
where is,
already
which
paid.
order? Which order?
My lord, page number. এই রে বার করে রাখলাম যে কোথায় গেল? My lord, the last annexure it will be. Page 152.
161.
Yes, 152 to 161.
161 is the last page.
Last page.
Yes.
That is below 22 crore 88 lakhs 46,098.
52 lakhs, 52 lakhs.
No, no,
50
interest.
হ্যাঁ, total সব
Tax
মিলিয়ে।
info total is yes. 52
Yes, 52 lakhs.
2,088.
Yes.
No, what you are challenging?
My lord, I am challenging this order, page 162. Here it's an
162.
yes. This is the second round of litigation. First, they had not given me the show cause notice. Now, after your lordship's intervention, I received the show cause notice and I replied, but they have failed to appreciate that this liability has already been discharged. It's a revenue neutral matter.
All right. The the petitioner has challenged the
Adjudication order dated.
What is the problem?
adjudication order
Dated October 8, 2025.
dated October 8, 2025. Passed under section 73(9).
73(9).
Passed under section 73 within bracket 9 of the WBGST Act. Full stop. The learned advocate appearing for the petitioner submits that though the petitioner duly replied to the show cause notice and produced documents in support of such contention,
Reverse charge mechanism claim has already been given.
yes.
They had to see the documents so that they can understand that I have.
Yes, so documents were not considered
Yes,
and
yes,
produced
yes.
documents in support of his contention, but the same were not considered by the adjudicating authority while passing the impugned order. Full stop. The learned additional advocate general,
But if you see, let's say 153,
yes,
they are, despite the issuance of fresh notice, they have not responded.
No, no, I have. That is what I'm saying. It is a reverse charge
The
mechanism
RP
case.
has filed a reply in response to fresh notice. The authorized remedy remains also appear for hearing. That is outside RPS. Reconcile the discrepancy as per point number 3.
Has accepted the discrepancy as pointed out
Yes.
and has made payment of liabilities.
Yes.
Therefore, the demand raised is hereby dropped.
Yes.
The
However, from the examination of available records and document funding, it has been observed that the liable to pay the tax is not paid on inward supply.
That is reverse charge mechanism.
Which is high, definitely, under section 9.
So I have already paid it.
Yes.
It is just in the other head. They need to see my returns.
কি বললাম? Yes, what do you want?
Let them approach to the appellate authority. But I haven't seen that.
This is a revenue neutral matter, my lord.
Because it has been considered.
No.
Well,
All right,
it is
then, my
been
lord, let the matter be. Then let the matter be taken up on 6th. I will make an elaborate submission on this. Let the matter be taken up.
Not today. Yes, call the next matter.
Good.
অন্য দেখেছে
Transfer order.
My lord, I am appearing for the DPSC Kujbihar, my lord.
Who is
My
the
lord,
authority? DPSC.
Council is the authority, my lord, but your lordship kindly consider one thing, my lord. Your lordship kindly see page 18, my lord, the representation, my lord.
Yes.
My lord, he has not annexed the receipted copy of the representation. My lord, how he has, my lord, served the copy of the representation upon the chairman DPSC, my lord. Your
Page
lordship kindly see.
18, DPSC, all right, I'm directing him to enclose this also along with the server copy. You consider that?
Lordship.
As your lordship, my lord.
Given the corrected copy, Lordship.
Corrected copy, in that copy, I think, ওটা দেখে নেবেন তো, from the date of receipt of a copy of the order along with the representation at page 18, ঠিক আছে? দুটোই ঢুকিয়ে দেবেন, representation dated 18th of July, ঠিক আছে? Same order হবে, ওই representation dated 18th of July 2025, ঠিক আছে? Transfer, আচ্ছা, authority হচ্ছে, ওখানে বোধহয় কারেকশন করে দিয়েছে, authority is the chairperson, district primary school council, respondent number 6 shall consider. এখানে correction করা আছে, ঠিক আছে? Yes, ওই along with the from the date of receipt of a server copy of this order along with the copy of the representation dated ওই 18th of July নাকি বললাম না এটা? Yes, call the next matter.
Same, Lordship, this is also same matter.
Same.
Yes.
My
Who
lord,
is the
I am
authority?
appearing for
DPSC Kujbihar.
my lord DPSC Kujbihar, my lord, in that case, my lord, the appointment was made, my lord, in the year 2021. My lord, 5 years has not been completed, my lord.
All right, you consider and pass an
As
order.
your lordship, my lord.
Yes. Authority is the DPSC
DPSC chairman, DPSC Kujbihar.
and representation dated 18th of July.
18th July, page 20, my lord.
Disposed of next.
This is also
My lord, in all the matter, your lordship kindly consider in all the matters, my lord, the representation has not been received by the chairman DPSC.
Why
my
have
lord.
you not submitted the representation?
three, Lordship.
This is also council.
Yes,
Same.
council, my lord.
Disposed of next.
Council, my lord.
Council.
Council.
Yes, my lord.
Disposed of next. 25.
Council.
Council disposed of next.
If you have 31, this all similar matter, Lordship, all the same.
Up to 31 same.
31.
Yes,
to
my lord.
31
Only
same.
the date of representations are different,
All
my
right.
lord.
Up to 31 same. Yes. Chalo.
Milord, before your lordship rises, Milord, one unusual request, Milord, item number 43 of today's list. Milord, this can be taken up on Thursday, Milord, among the first 10 matters at least. Milord,
43.
43, Milord.
43 is fairly at the top, Mr. Ghosh.
Milord,
Subject to how many new,
Milord, that
what
is
is the
creating
urgency?
the urgency is, Milord, that a dumping ground has been created at the heart of the city. Milord, several civil movements, Milord, to groups.
Who is appearing for the other side?
Milord, the municipality is appearing, if Milord indicates, Milord.
Who is appearing?
Milord, the Jalpaiguri municipality is the answering respondent.
Yes.
But I will.
Who is the learned advocate?
Milord, generally, Mr. Pritam Das appears for the municipality.
Yes. Where
Milord,
is Mr. Pritam Das?
Milord, Milord, I'll intimate him if your lordship indicates that it will be within the first 10 Milord matters. Milord, I'll
First
indicate.
10, Mr. Ghosh, it's difficult because I do not know how many motions, new motions. will
I
come.
understand.
Let it appear. I will please inform him that he will be mentioning. I will consider
Lordship,
that.
may I?
My lord.
Just one thing, Lordship. Lordship, item 37, similar thing. There is an urgency, Lordship. A connected application is there. Lordship, there has been a.
All right,
procedure.
please
Can it
come.
be there at the in the first 10 matters, Lordship? Item 37.
All matters cannot be in the first 10.
No, it is